Titles in Commerce, featuring NTT, New Trust Technology. Presenting your host, Christian Walters.
Welcome, everyone, to this 16th 2010 edition of Money, Banking, and Trust by Moving Titles in Commerce. I'm your host, Christian Walters. Welcome to NTT as New Trust Technology, and we'll do the disclaimer next.
Take notice and acknowledgement with agreement that this show and or documents is private and not to be construed or relied upon as being legal advice for an individual legal situation or implored for making a legal decision. You will not use any of this information for making a legal decision or performing a legal procedure and is not a substitute for legal advice and or guidance by a licensed attorney. This private show and or documents are for academic informational purposes only to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show or using the documents therein, you understand with agreement that, with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state, and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of herein referenced, and has no interest in any use referenced therein, and is not a party to this or any action arising from, and is only acting in an authorized capacity as liaisons to communications between the parties. By reading and or using this information, you acknowledge and agree that you are not a client of Christian Walters. These documents and or show recordings are incomplete and void without this notice agreement being attached herein by reference, and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more per stultification or impairment per Christian Walters' discretion. Thank you for your understanding.
Again, I'd like to welcome everyone to this Monday edition, August 16th. Welcome to NTT as New Trust Technology. I'm going to skip the corpus juris secundum reading, so we're going to jump right into the Q&A. So to raise your hand, press *6, *1 to get in the queue line and ask a question. Press *6, *1. Press *6, *1 to get in the queue line, ask a question, where you're from. Anybody have a question? We'll get right off to Q&A. 612, you're unmuted.
Rick Strauss.
Hey, how are you?
Good. Friend of Tammy's from Minnesota.
Uh-huh.
And we're just going to listen in this evening and follow along.
Any specific questions or anything you want to ask? Or?
Well, I'm loaded with questions, but you may be answering them as we proceed. So,
fire away.
Well, one of the areas would be with regards to remedy on a short sale that occurred recently with my home. Actually, it occurred over a year ago, about a year and a half ago, and so I'm pursuing information on how to possibly take that matter into court. I know it's a process, but I'm willing to listen and find out.
Mm-hmm. Are you pretty new to the call, are you?
Pardon me?
Are you fairly new to the calls? NTT?
I'm new to this call, but I'm not new to the information per se.
Okay, because I was going to tell you that where to go to get the information, listen to the past audios from last November, 11/7 and forward.
Okay. Let me write this down. 11/7.
Yes, 11/7 of 2009. So anything forward from that date is all NTT, because that 11 was a debut of NTT as New Trust Technology.
Yes.
And that's what I would use in your situation.
Did you say? Oh, that was. Did you say 09?
Yes, 09. 11/7.
Okay, 11/7. Okay. Now, where would I find that?
Okay, if you do a Google search for my name, Christian Walters, in quotes,
Okay, I am. Okay.
NTT
Yep.
afterwards,
Yes.
it'll pop up one of the, within the first three hits there will be a ForShare site, and that'll take you to all the audio downloads.
Okay, audio. All right.
Then just look for 11/7 and forward from that date, because that's the NTT debut.
Okay, very good. Well, for this evening, are you in the middle of a lesson now?
Well, I usually have been reading something from, say, like Corpus Juris Secunda, Book 90 on trust, but I kind of want to make tonight kind of short, so I'm not going to read out of it. We've been studying that.
Which, how many volumes are there in that series?
About 160 volumes. Corpus Juris Secundum is a total body of law in the United States.
Yes.
And it's broken down into sections, and one of the sections, Book 90, under trust, the trust section is about 1,000 pages.
Well, that is certainly a lot of reading.
Yeah, we're on, I forget what page we're on exactly, but we jumped around a little bit. But yeah, my intent is to read the whole 1,000 pages online and have an audio for the whole thing.
Now, were there various editions or prints, or what your copy are you?
My copyright was 1955, and there are some different other versions out there that probably won't read the same, but what we've done, we have some people who have done some copying, and they have PDF copies of what I'm reading. So on that site where the ForShare is, you probably get the actual PDF form of the Corpus Juris Secundum that I'm reading.
Okay, now just so I understand 100% here, I'll Google your name, and then NTT comes up.
Yeah, if you Google my name in quotes, Christian Walters in quotes, and then
in quotes.
Yeah.
Okay.
Then afterwards or NTT before it. Either way.
Oh, okay. And then the topic that I'm actually searching for in these formats would be what topic?
Well, if you look on the .com line, the last line in the hit, it'll give you the web address, and you want to pick out the web address that says ForShare.com.
Oh, ForShare.
Yes, number 4 and share.
Oh, okay. All right, ForShare. Okay.
And then that'll take you to the ForShare site, and that lists all the audios that are. And then just look for 11/7 and pick out 11/7. Start there and download that and forward till present.
Okay. Okay. All right. Well, I'll start that search now. That would be yes.
Prior to 11/7, and it was debtor creditor, and after 11/7, I'm totally staying away from debtor creditor.
Okay.
All I'm doing is NTT trust. All I'm doing is trust. Everything is geared on trust from 11/7 forward.
All right.
And NTT is basically a way of paying your bills by extinguishment of the debt through a trust.
As opposed to acceptance of value.
Creating a debt instrument on the debtor-creditor side and actually asking a debt to pay a debt which doesn't pay anything. It just mounts the debt up. Trust is the only vehicle that extinguishes the debt by a merger of the two debts.
Okay.
But we're not creating debt under trust. We're extinguishing debt, and that's the only way you can get rid of the debt. The only thing you're doing under debtor-creditor is you're doing exchange for a promise to pay later on, and you haven't paid anything. You just mounted it up.
Right.
So that's not to say you can't get a remedy under debtor creditor, but in the ultimate end, it actually leads to your downfall. So
one has to get out of that thinking.
yeah, because the mounting up of the debt and never extinguishing the debt is the downfall of it's created our problem that we're in today. We have too much debt.
So that acceptance of value is not really a good remedy.
No, that's creating a negotiable debt instrument and asking that to pay a debt, and that's just mounting more debt up.
So the information you're going over, does it cover? Are you covering this specific remedy currently, or?
Well, the basic stuff has been, back 9 months ago when we kicked it all off, and we went through that pretty well in depth. And right now we're on more advanced stuff. And to get what we're talking about here on, say, jumping in on the deep end of the pool here, it takes got to go back and get the audios and get the nomenclature down, the terms down, and the concepts and the models and basic way of forming the trust. But all that was gone over and explained on all the past audios.
Okay.
That's where you have to start 11/7 of 2009 and forward.
Okay. And catch up.
Mm-hmm. That's the hard part. You've got 3,000 plus hours worth of audios to listen to.
Okay. Well, I will let you carry on then. And do you mind if I listen in tonight at all?
No, that's fine. But we do have some of the TAs, the trust ambassadors. If you get a hold of some of those, we're coming out with like an index of some of the important audios. And if you get those first, then that will give you the highlights and the more important points, and the rest of it then you can fill in later.
Okay.
So if you could Skype Faith to Trust, that's F-A-I-T-H and then number 2 and Trust, T-R-U-S-T. She'll give you the more important dates to look for in those audios.
Okay.
We talked about special deposit. We talked about withdrawal and redeposit. Different topics that's key to what we're talking about.
Okay.
How to end the guardian-ward relationship, just different things.
I'm just taking notes as you speak, so I appreciate that. Well, thank you, Christian.
Okay, I appreciate it for coming on.
Thank you.
Next caller, you're muted.
Hey, Christian, how are you? This is Darren.
All right. Hi, Darren.
How you doing? Had just a question, especially in regards to a notarial protest. Once that is complete and completed via certificate of dishonor, which is basically the whole step, can you just file basically a UCC1 just as a public notice against parties that they've acted in dishonor? By estoppel by acquiescence, just as a public notice, and even state a damage in there, which is basically nothing more than a notice of interest. In other words, it really doesn't hold any validity because it's really not serving as a lien per se, but it's just basically reflecting off the original documents that you're holding. Now, of course, if there ever becomes a lawsuit that's initiated by that, now you go through of basically the statement of interest and your UCC3 and everything else. Is that correct?
Yeah, that would be under debtor creditor, but under trust, we don't do a notary protest.
But isn't that
notary protest applies to negotiable debt UCC in Article 3 there under 501, 502, and 505. So we don't do a notary protest. We're only using the notary for presenting and acting as a witness for the delivery in the formation of the trust, or just acting as a witness that they got the documentation.
Okay, but can't the notary serve both on the public and the private side as well?
Yeah, but we're not doing the presentation, a presentment of a negotiable debt instrument. Everything we present is non-negotiable and is not under UCC.
Okay. So
a notarial protest.
I see. So let's say for an example, if one did that and followed it along that sequence, how can we amend that and correct it? Remove it?
Yeah, I think if you did a notarial protest on the stuff, yeah, you'd have to remove it, yeah.
I see. Remove it and then just hold it privately.
Yeah. Mm-hmm.
Okay, so that would be the best thing to do is just totally remove it.
Yeah.
Okay.
Yeah.
Okay, that was when...
If you're doing a non-negotiable instrument, that a notary protest only applies to negotiable instruments, so...
Okay. Wasn't sure because really it was
we're just using the notary as under his hand and seal. He's going to certify an act that he did.
Just a witness, basically.
Yeah.
Okay. So basically have it removed. All right. Okay. Yeah, I just wanted to be sure because, like I said, this was done a long time ago before we really got into a lot of the nitty-gritty that we're getting into now. And I just wanted to be sure. I didn't want to commingle it and go debtor, creditor, and trust on the same thing, which kind of sounds like it's doing. So best thing to do is just remove it and start from scratch.
Yeah.
Okay. All right. Fair enough. That was my only question.
Okay.
Thanks.
Thanks, Darren. Okay, anybody else have a question? Press *6, *1 to get in queue line. Or anybody have a second question? Come on back in then. *6, *1. Anybody have a question? Press *6, *1. Somebody, don't be bashful now. I'm sure you all have questions. John, you're unmuted.
Good evening, Christian. How are you this evening?
All right, good.
Well, good. Well, I've got some questions on an indenture. Actually, it's a modification of a previous trust indenture. I sent one, and it was it was incomplete. I just didn't get it right. And I wanted to run this past you to see if you had a similar situation, if it would work for you. This modification is to remove all doubt as to the purpose, parties, and duties of all trust principles. Elements of the trust, this is a heading. Number 1, the intent is to create a specific relationship manifested by grantor's words and or conduct. 2, the purpose is to maintain a specific relationship between grantor and beneficiary and the trustee that is lawful. 3, special trust property res is the grantor's signature on the SS5 form creating Social Security account number, Social Security with the dashes. Number 4, the parties of this express trust are grantor, my name, beneficiary, my name, and trustee, I have appointed an IRS agent in his name. Method of transfer is the next heading. This special deposit is being transferred to the Internal Revenue Service via delivery to the agent's name and is now being held by him. Grantor hereby appoints that agent, authorizing officer as trustee. And then the next heading is order. This is a re-entry by the grantor settler whose exigent circumstances expresses his intent to grant the equitable assets of the original segregated special trust res, Social Security account number with dashes, deposited for a specific purpose in the past, held by the trustee in the agent's name for the benefit of the beneficiary, my name, as the account beneficiary to be returned to the grantor settlor on the grantor settlor's orders at a future time, or I don't know whether it should be at the present time, along with all trust res and principal interest. The undersigned herein and after is grantor of this confidential relations expressed revocable private trust modifiable from time to time, is confident with age of majority and power to choose, and has all alienable rights, titles, and interests without granting any waiver of any rights, remedies, or defenses, now comes in good faith under 1776 AD law form with purpose of all laws of nature, and nature's God specifically instructs and specially orders the following within so many calendar days of receipt. Number 1, grantor hereby orders that all past general deposits be withdrawn and redeposited as special deposit effective immediately. 2, convey trust res to funds appropriate to extinguish all debts related to liens with the lien numbers by modifying grantor's signature. 3, provide a complete accounting of all transactions and return any overage to grantor, so ordered by grantor.
Okay, I would say, I think it was number 2 you meant, you said it was convey?
Convey, where was that at?
I think it was in number 2 there.
Okay. Convert trust res to funds appropriate to extinguish all debts related to liens number so-and-so.
Okay, so it is convert, right?
Okay, what did I do, say convert? I said something else.
So
okay.
Convey, yeah, you said
okay.
convey.
Okay, convert trust res to funds appropriate to extinguish all debts related to liens and so on. The number.
Okay. Yeah, convert's the right term. When you said convey, that caught my ears. So.
Okay. Yeah,
and then back up where you mentioned the grantor. Are you the grantor on there yourself? And then who's the beneficiary?
I am.
Okay, so is there a distinguishment between, say, the real man and the fiction, between those two parties?
Okay, I see where you're coming from. No, there's not.
Like the grantor would have to be, say, maybe in...
with the all-cap name?
Yeah, and then the real beneficiary would be on the private side. That would be the real man, so that would have to be upper and, say, lowercase. And then just for an added protection, you might want to consider putting another beneficiary in there so you're not the sole beneficiary. Because I know the IRS doesn't like to see a trust where the grantor and the beneficiary are the same name and being the same party, even though they're not the same party. Although the names are idem sonums, they're similar as, that term, identical of identity of interest, which is the two names are so similar they look the same. So, but if you have a second beneficiary on there, then you can name yourself as grantor and beneficiary because you're not the sole beneficiary. And that may just eliminate that problem. So now you might be able to defend that because actually the straw man and the real man are two different entities. So
okay, the grantor should be the all cap name, right?
Yeah, because that's the one that shows up in the, say, well, it depends how you're playing it. If that document's going to show up in the public, then they like to see, the trustee to be the straw man.
Okay.
So you could be playing the grantor as the real man, or you could be playing the grantor as the straw man, or you could be playing the trustee as the real man, or the trustee as the, it just depends how you think you can defend it.
Well, this is pretty much the way I understand it.
Now, with just the IRS, they may not question him with all that stuff either. Because you get into the private side with that, and they know what you're talking about, and
Well, do you think the IRS agent is high enough up the food chain to understand that, or do you think he'll pass it on, or?
No, I don't think the regular guy that's coming at you from the right hand is going to know anything about what your left hand stuff is you're doing. He's just a collection agent.
So, what are you saying, that this is going to fall on deaf ears, or?
Well, no, I can't actually say for sure. This is kind of like new ground right here, how we're making these fine nuances, how they're going to be fine-tuning this.
What do you think?
I'm just going by the problem that the IRS could come in and say, you've got yourself appointed grantor and beneficiary, and they don't like to see that. But this is really a private trust, and they might not say anything. So,
it's been suggested in our group that maybe we should send it to the CFO of the IRS, and that's Doon.
Yeah, that could be getting back on the private side, because I would think he would put it on the private side instead of on the debt side, especially if instructing him to.
So you
made all the whole problem.
Well, I guess what got me started down this road was Jeff, I think it was, in Washington, said he had an IRS agent.
Yeah.
And this is the agent that filed the liens into the county, and we're now in bankruptcy, and he's the one that's on the, of course, they're just copies of the same thing that's in the bankruptcy, but...
Yeah. Well, now, I may be bringing up an issue that might not be relevant. I'm just pointing out the fact that, to get around that, what they would make a claim for, that if you had two beneficiaries there's no way that they can claim that. Because now you got beneficiaries.
Who could I claim as the other beneficiary?
Are you married?
Yes.
Oh, your wife.
She can be a beneficiary of this trust?
Yes.
I don't think that's ever come up in anything that...
But now you have you and your wife being co-beneficiaries. Those are two entities, two parties.
Okay.
But so either her or maybe somebody else, even your kids, or some independent party. But I know that as long as you have more than one beneficiary, you can be grantor and beneficiary at the same time because you have another beneficiary. And then they can't claim that, there's what do they call it, an alter ego trust.
Oh, okay. Well, so you think the CFO of the IRS might be, would you send it to copies of everything I'm sending to him to them, or would you just kind of, I've already addressed him once, but like I say, the indenture was...
Him all my original stuff, and then send copies to this IRS agent, whoever the trustee is.
Well, how about making them co-trustees?
Yeah, you could do that, yeah.
It don't sound like to me you're too encouraged to that. Okay, well, Okay, well, I think you pretty well answered my questions. All right, one more thing before I go. Should I put all of my NOIs and SOIs together and send with them with my SS5 application and the Social
Yeah, whoever's the
Security?
trustee, I make sure the trustee gets all proof of everything. He's the other party, so.
So I should just get everything together and put it all in an envelope and send it by registered mail to the CFO, and then send copies.
Whoever the trustee is, he has to get all the documentation. Has to be fully aware of everything. So they can't come in and say, well, no, you never sent this, you never sent that. No, I did send all this. So you got it all. Here's the proof.
Okay, and send that by notary certificate. All right, Christian, that ought to fix me up. I would think.
We're just on so new ground here. It's like, I can't actually say, how this is going to go, what they may bring up, because nobody's ever done it before. All I can do is throw out the possibilities, and if there's a possibility that might happen, that they may say that, well, this is an alter ego trust, we don't look at it as being a trust. The workaround that would be another beneficiary.
Okay. And her name should be, now my name should be in uppercase as a grantor, and then in lowercase as the beneficiary, and her name in lowercase.
Again, that's another question. The experience has to be better.
So you don't know of anybody that's tried this?
Not yet, no. That I can say that those were the issues that they picked, and that those might have been stumbling blocks, but I can't say. I don't know of anybody that's really done it.
Okay.
It may slide by the first time. Maybe they might say, get a little wiser, and they may pick up on it. I don't know. We're right in the crest of the wave here.
Okay. Well, let's hope maybe I can slip it past them. All right, Christian, thanks. That's all for me.
Okay. Marshall, you unmuted?
Hey, Christian, how you doing tonight?
Okay. All right.
All right. I have one question that popped up into my head just a little while ago, and my question is, say like if you were to go to like say a mortgage closing, and you were to sign a note, and you sign it under as a general deposit, like a retail installment contract or something like that. Now, when you re-express or remodify this trust by the withdrawal of the general deposit and to redeposit as a specific for extinguishment, you would have an order, of course, to compel the trustee or the co-trustee to do a specific duty of extinguishment. Now, that original signature or asset that is on that original note, that should be used to extinguish the entire debt. Now, my question is really, is it still necessary to do a separate merger of a debt title and the creation of those records to prove a payment has been made if you have to go into the courtroom and prove that a payment has been made, by trust receipt and indenture? Is it still necessary?
Well, the first one is just a formation of the trust. So if he gets the trust res, then there would have to be, say, a second one to get a specific debt.
You asking me a question or are you answering my question?
Well, that's kind of what you're making reference to?
Yeah, basically, yeah. Okay, no, because what I'm saying is that original note, the original quote-unquote wet ink signature, once you give that to them and you re-express it as, say, a specific deposit, although you delivering that res to them, that asset title to them, is the formation of a trust, can you not order them at that specific time to do a complete extinguishment?
Well, I think the note has a known value, so there you got a value of a certain amount.
Okay. So then it is possible to be done, or is the only way to really truly go about it is to actually receive the offer from them and then merge the title, or extinguish the debt, I should say.
Well, what would the debt title be?
Say a bill, quote unquote, a bill that you would get, or a mortgage statement every month. Like thinking of it in a situation where somebody's a homeowner, and
where does the bill arise from?
Where does it arise from?
Uh-huh.
A misconstruement of there being a debt owed by you.
Well, no, there's an actual document. What would the actual document be? You're talking about a mortgage situation, right?
Yeah. I'm just speaking in like a hypothetical term because I don't know too much about the mortgage.
The bill rises from the security agreement.
Right. That would be outlined in the retail installment contract, right?
Oh, probably is, yeah. So
yeah,
that title is your security agreement, and your asset is your note. Merge the two of those together, and they're gone.
Right. So now my question would be, like, would you be able to come in and re-express that and have that merger to extinguish the debt, or would you have to actually get, say, a bill in the mail from them, and then you turn around and merge that title and send it back to them?
Incorporating interest and all the other stuff they're trying to hit me with on top of that,
Yeah.
So you got the equitable asset, the application, which does value on it. Now you got a limitless equitable asset that you can use to extinguish anything with.
Okay, well, it was a chime in just now. Say that again? I missed a piece of that.
Equitable asset, the application with your signature on it, has no value on it, so it's unlimited.
Right.
So you have an unlimited value which to apply against anything that they would come at you with as an additional bill.
Right.
All I would need to do would be to take their debt title and merge it with that, because that would take the lower and extinguish it in the higher, and the higher is always going to be there because it's unlimited.
Okay, so now in that situation, you're specifically speaking about the original note, which is that.
No, I'm talking about something a little different. The original note is one thing, and the original security agreement, that's like one, but then you still got the application and maybe some additional bills, which would be interest that you're trying to charge you or other fees.
Okay, so the application being the very first document that you would sign?
Yeah, or I could take the bill that they're going to send me and use that as trust res and turn it right around and redeposit that.
See, now that's the one that I'm familiar with, and that's the question that I'm asking you. Would that technology or that process...
There's really all kinds of ways of playing this if you stop and think about it.
Right, so that's what I needed to hear you say. That's what it was, right there. So,
it's like whatever you put your signature on in the past, plus anything you can put your signature on now or in the future.
Right. See, I was thinking it had to be an either-or type of a situation because it was looking like you were making a double payment. Because
the note would extinguish the security agreement, but then if there's an additional payments over, say if my note was, say, $100,000 and the security agreement was $100,000, the two should cancel out. But if there's interest on top of that and other fees, over the 100,000, maybe
Right.
they may match you with those.
Yes.
Well, I could apply the original signature on the application, that equitable asset, against those and extinguish that. Or I could ask them for a new bill, give me the bill, and I'll put my signature on that and turn that back in and redeposit that as special deposit, extinguishing that debt. So I could do it either way.
Perfect. That's what I was wondering, whether it had to be either or can it be, that's what, see, I'm more familiar with the latter. That's what I've learned from you over time, taking their debt title that they send to us, that offer, and merging that title with your asset. Now, that's why it just came to me a little while ago. I'm like, well, what about the original and the first signature? Like, what are we going to do with that? Now you cleared it up for me.
So I'm always going to be thinking, where is my past signatures, and are there any known values on that?
Right.
And then if there are some new stuff that comes at me, I can always put my signature on it and turn it into trust res and use that as an extinguishment.
Exactly. Okay.
So it all comes back down to the signature. It's where has the signature been applied in the past? Where can I apply the signature in the future?
Right. But now the latter would also be a way, the second scenario would also be a way to create a record of a payment.
Yes.
How would you create the record of the past payment as far as the first from the, say, original application?
They still have to send me a bill.
They still have to send you a bill first.
Mm-hmm.
Okay.
I could either use the old signature or create a new signature and put it on top of the bill and send it back in.
Okay, it's a lot more clear for me now. So the process is relatively the same. It's just, like you said, you finding everything that you put your signature on and finding a way to apply it.
Right. Pretty simple, really.
Yes, it's very simple. Very, actually. So it's not all about creation of new asset titles on top of a offer or a debt title. It's all about you can use what you've already brought to fruition, I should say.
Yep.
It's there already. Use that. Interesting. Very interesting. Okay, so you said the application will cancel the security agreement, right?
The note will cancel the security agreement.
Yeah, the note will cancel the security agreement.
The application will also cancel the security agreement.
So, okay, either one, either or.
Right.
So is there a pair or a couple that's more synonymous with each other or more dualed and coupled with each other? Would it be the note and the security agreement, or would it be the application and the security agreement, or the application or whatever? Like, is there...
The more colorable one would be the note and the security agreement.
That's what I needed to hear. Okay. The colorable one, I need to write that down. Note and the security agreement. That's what I was driving at right there. I needed to know how to differentiate the two. Right. That was...
The note and the security agreement should be of an equal value except for the interest, but the interest is mine.
Actually, yeah. So the interest is yours. So now, once you re-express the trust and you give an order to apply that asset, then you call back the interest through that same order, right?
Plus all the payments.
Plus all the payments.
And then I want the bonds and everything else that you've taken from my original signatures, and I want those proceeds also.
Right. Yeah, I've heard you say that many a times. Right.
So it just depends on how far I want to go.
Okay, I know this stuff is not exactly new. It's just I just needed a little bit of reinforcement with a couple of things as far as that was concerned. And I think that's about it. Something else. Was there something else that I had to ask? Hold on a second. No, I think that was it.
No more questions? All right.
Huh?
Pick up another one real quick.
Okay. Well, what I'm really trying to focus on now is because I'm at a point where I'm going to just be honest with you. I'm at a point now where I'm ready to make some moves, and I'm not waiting on these people anymore. Like, it has its advantages to have the proceedings start on you first, but like I was stating before, like, I would want to feel kingly, like I want to be the one to do it. You understand what I mean? And I'm preparing myself, and what I've been doing was trying to stay focused on, rules of evidence, civil rules of evidence, and, procedure, and my maxims.
Yeah, and there was one maxim that says that you should start out right away. So.
Yeah, exactly. And I'm tired of this, and I just want to get this over and done with, and I really, really am so confident with the application of NTT. Is like I have no doubt in my mind. Is just I don't want to fall through some technicality of something that I do wrong. And,
because I think what they're going to wait on is they're going to hope and pray that nobody comes at them because they're going to claim latches.
Yes. Yes. Yes.
And then if they start claiming latches, then you got a different problem, because now I explained to the judge why you waited so long after you knew there was a breach of trust. Why didn't you come at them for a breach of trust?
Mm-hmm.
Which lends credence to the claim for the latches and nullifying your equitable claim.
Right. That's right. Well, everything is right on time for me, because I said to myself within the next 30 days, like, if they don't bring me, I'm bringing them. And not to speak about any specific situations, but, it's time. I was just waiting for, my records to come back. Got all of that together, and it's time now. So I guess
if you wait maybe just a little longer, maybe we might have a way of coming at them where you really don't have to come at them in court. And then it looks like we also have a remedy for if they do come at you at court, that we can do withdrawal of the court and the extinguishment of the debt. So I think we've them hands down. It's just a question of getting enough people that have the knowledge to go ahead through this, and if they ever get put on the spot, they could, explain what their intent and what they're doing.
Right. So then would it be, how should I say, something that would be beneficial to jam it up for a little while and continue to do a little bit of digging and researching?
Well, what we're working on is, to have the IRS handle it all before it gets into a court proceeding.
Right. Right.
So that way you don't have to enforce it in court. The IRS goes and takes care of it for you.
Yeah. Yeah, and that's definitely what the discussion and the topic has been. The only thing about it is,
did you hear the call last Saturday?
Say that again?
Were you on the call last Saturday?
I don't believe so. Well,
I'd get that call and go over that one, because Chris and I were talking about it, and we just had a major brain bingo on that call. And that was with the withdrawal of the total case by the defendant, not the plaintiff, the defendant.
By the defendant, okay.
So if they come at you as plaintiff and come at you for the debtor creditor and you're going to defend it as trust, it can be totally withdrawn, the whole case. And what we're doing, we were trying to do it on a microcosm, trying to go in and get the DIB hearing and go in chambers and that. But now it turns out that we could probably do it on a macrocosm, take the whole case, do a withdrawal order on it as grantors, and withdraw the whole case. Order it closed. Order it withdrawn.
Christian, didn't...
One step farther, and then extinguish the debt and go after the proceeds.
You said that before.
Yes, I know.
You said that a long time ago.
I know. I know.
Yeah, I remember that. That's not new to me. You've been said that you would be able to use the entire case itself, take the case number, and redeposit that as a special deposit.
Well, we've had several people, 2 or 3 or 4 different scenarios, cases that just went bye-bye just by using the withdrawal. Should have gone one step farther, use the withdrawal and the redeposit and the extinguishment of the debt, because I'm not sure whether the debt was extinguished. Although the case was withdrawn, it was ordered withdrawn. Right. And it was withdrawn. It closed down.
And that had to have been because all quote-unquote crimes are commercial crimes. They're only after their money, so if you extinguish whatever it is that they're looking for, then they're happy. Everybody goes home.
Yeah, but under this particular case, I don't think they went that far. They did the withdrawal, but they didn't order the extinguishment.
Right. Right.
But I would order the extinguishment along with the withdrawal and then go after the proceeds.
Right. Now, that part is the going after the proceeds. That one is a bit, well, I wouldn't say new, but I didn't piece those two together.
So we kind of went over that on the Saturday call with Chris, and we had a pretty good discussion about that. So,
well, I'll tell you one thing. I spoke with one of the TAs the other day, and he gave me the code or whatever the case may be. Well, to tell you the truth, being that I told you I was thinking about really getting this done within the next 30 days, one of the biggest things that I was going to do, being that I've been doing so much reading lately and studying, I haven't really been paying attention to the calls. Like, I'm listening, but then I got files up. I have 2 computer screens in here and doing this and doing that. And one of the things that I know that I'm going to do to help myself prepare and is to go back through those audios that I've been missing over the last couple of weeks. And I would definitely recommend to everybody, like, everything that you need, all of the new people, even some of the people who have experience with NTT, like, go all the way back to the beginning and start all over again. And the last probably about 4 weeks, probably like this last month, I really have to go through, especially when you are going through enforcement of the trust. And you spent about 5 shows worth of time really going through, I think it was, book 90A, right?
Yeah,
that
starting
you've been reading lately?
In 421.
Yeah, exactly. And that's something that I was going to deal with that when I'm really focusing in on my maxims and learning, because I see it as, I went over all of the maxims, I went over all of the maxims, and it's about 5 of them where if you know these 5, and there's a specific 5 that I'm talking about, and at least 3 of them we've spoken about on the calls. If you know these 5 maxims like the back of your hand, like, you are unstoppable. There's nothing that they would be able to do, nothing they can say, nothing that they can come back at you with, because we are in equity, and it's a total different ball game in there. And, like, it really clicked for me the other day, knowing my maxims, knowing the difference between general deposits and special deposits. And before even getting into equity, it's very important that we know civil rules of evidence, federal rules of evidence, civil procedure and federal procedure, because we have to go through that at-law side first to even get into equity. And until I guess our bills and our pleadings are put together so well that, no adequate remedy at law. You have to see me in equity automatically. But I'm just speaking of situations where you need temporary restraining orders and, mandamuses and whatever, what have you. You know what I mean? Like, it's things that we have to learn on the at-law side also. I know it's all about equity and it's all about trust, but we still have to learn and operate in that realm to its smallest degree and its smallest capacity to be able to get to our yellow brick road, I should say, which is equity.
Yeah. We have to be, as kings, know how to do everything a king knows how to do.
Right. So this is what it's a lot. I tell you, it's a lot, but once you grasp it, it's kind of easy once you get, the basic model down. Is just learning so much. There's so much to take in and to get into. Another thing I recommend to everybody new, and this is something that I'm going to do myself also, is to go back to Gilbert's. Gilbert's is a very, very, very important book. Like Gilbert's, all of the models and the visualization, like you would say, like everything we need is inside of Gilbert's, and some of the transcripts that we have already, typed up and ready to go, and the audios, like we got everything that we need. And the other night when you came on the call and you were, speaking about how you're not going to go back, like people are jumping into the deep end right now. I felt that, like I could definitely understand that, because when I first found out about NTT, I was about 3 months behind. When I went to November, you was probably already into December going into January. No, as a matter of fact, you were already in January. And I had to study through November, December, and then catch up into January before I would even think about trying to get on a call. And I wasn't listening to any of the live calls for months. I was just so stuck on the audios, because everything is there. Now, certain things have changed, switched up a little bit, but the basic model, and like how we say, go back to Gilbert's, like we read the whole entire Gilbert's book, and we went through reinstatement of the third, and it's a lot of information out there. Like how you was telling the gentleman, I didn't know it was 3,000 hours.
Yeah, 3,000 hours.
That's a lot of time put in, and I just wanted to say to all of the quote, I don't even like to call them newbies, but to the newer individuals who've just discovered NTT, and whether you're having a time grasping it or however it is that you learn, just be patient with it. Don't jump ahead of yourself. Go back to the beginning, get to the basics, and you learn the basics. Like when all of the flashiness and the glitz and the glamour, like say for a professional athlete, a basketball player or whoever, they're young, they come out, they're jumping all around the place, over the rim, and but then as they get older, they have to return to the basics to put those same numbers up, to keep their averaging and their scoring up. And I'm a big basketball fan, that's why I use that analogy, and I see people do it all the time, like say Tim Duncan. He's just a basic player, but he's such a great player, and I equate that to NTT and learning the basics for all of the newer individuals who are just coming in and jumping into the deep end. And you get in the chat groups and you're asking questions, and those questions can't.
I think they're expecting too much, because this is so new. It does not exist what they expect.
Right.
And we don't have the manpower. It hasn't been created yet.
Absolutely.
We need all the audios, at least the more important ones, all transcribed. People have to step forward and volunteer to transcribe these tapes.
Right. Absolutely.
It does not rely just on me. I've spent 3,000 plus hours worth of talking. What have you contributed?
Yeah.
We need people to step forward and transcribe these audios.
Right.
We've got some that are partially transcribed. We need to complete them out, and we need to start putting an index together with the TAs of all the topics, and go through all the audios and categorize them according to topics and code them into a time sequence so that if you want UCC documentation, we're talking about a UCC 1, it shows up as being on 11/7 and 12/10 and 1/27 and, you know, all the dates that applies and all the audios all pops out on a printout.
You know what, Christian? I just wanted to let you finish talking because that same exact thing that you said is exactly, and this is my word to everything, like that's exactly what I did myself. All of my notes, when I first started getting into NTT, what I used to do was I would listen to the entire audio first. I would go back and rewind certain things and listen to the entire audio, and then I would go back to the same audio before I moved on, and I would take notes, and I would timestamp certain things, like certain things that jumped out at me. I would say it was 58 seconds into or 58 minutes into the call or 1 hour, 30 minutes into the call. And so many of my notes in the beginning was set up in that exact format, and that way I was able to find things. So I would definitely be able to help with that because I have a lot of that done actually right now as we speak. I just got to go into all of my old notes.
Get together as a TA group and spit out the topic or how we want to categorize it, what specific word we want to use.
Right.
Moving titles platform. Well, that breaks down to, say, UCC 1s, UCC 3s, and that would be a subheading off of moving titles, say. The TAs have to put together a master documentation so that we can organize all these audios, and then somebody's going to have to start stepping forward and listening to the audios and plugging in the time codes.
You know what? I'm looking at it right now. Like I grabbed one of my old notes, and from the beginning, 11/11/09, at 18 minutes in, I have you were talking about if the judge violates appointment of trustee. This is what I have written down. At 20 minutes and 50 seconds in the court, we want to be grantor/beneficiary. Out of court, we want to be grantor/trustee. 26 minutes in, unincorporated association I have, and 1 hour, 47 minutes in, you were talking about the UCC, and there was a gentleman in there, he was saying that we should get a Uniball 207 pen, and the Hague Convention, UTC at I got a lot of this stuff written down already.
Right, well, that one we can use so we can plug it in and utilize it somehow so we can use it for the rest of the audios.
Yeah, because that was very, very helpful because it was just so much information. There were certain things that I just could not remember where it was on a 2 or 3 hour call because you would go through so many different things. So that's why I used to write those timestamps like that so I would be able to find it and go back in. So like I said, I have a good 2 or 3 months, transcribed out like that, which would be a good jump start, actually.
If we're going to do that to 3,000 hours worth of audios, we're going to need a lot of help.
Yeah. Well, I'm just letting you know I got just a little bit because that's what I was doing myself. 11/7/09, you was going through the SS5 form and I got a lot of this stuff. Yeah, I definitely share it with the group so we can get some of that. I tell you, me, myself, personally, I'm going to be so much more of a bigger help to the whole NTT cause and the movement once I get these people out my hair. It's like I've had tunnel vision knowing what I need to know to get this stuff done. You know what I mean? And once I'm able to get them out of here, then I'll be able to breathe and, dedicate more time into my studying because there's a lot of stuff you've been going over that I listen and I pay attention to, but I haven't been absorbing it like how I usually absorb information because, I have to take a different lane in certain ways to accomplish the specifics that I need to get done. You understand what I mean, right?
Right, yeah.
Yeah, so once I'm done with that, then my peripheral vision will start to work again, and I could get out of this quote-unquote tunnel vision, because I have one focus and one focus alone, and that's to extinguish this debt, create these records, and if I have to enforce it, I'm going to go in there and I'm going to enforce the hell out of it. Simple as that. So that's what I've been focused on. So once that's done, I'll be able to open up more and, you know, help out more and do more things. But I'm definitely advocating for time stamping those tapes like you're talking about.
For all the newbies and people on the calls that are new, it's just that the information does not exist. The information exists. You just don't know where it is.
Yes.
And we don't have an index to where it is because everything's too new.
Yep.
And there's only one person can do so much. That's it. And it requires other people to jump in and say, hey, be responsible here and contribute. Don't just come on the call and take. We've got enough takers in the world as it is. Be a contributor. Be a giver. Give your own time. Pay it forward with your own time.
That's right. That's right. Sounds good to me.
Volunteer to do an audio transcript. We'll give you the program. If you can type, you got good typing skills, hey, do one tape.
Mm-hmm.
It takes about 10 to 12 hours to do one tape, depending on the size. But once it's done, that's just one more.
Yeah. And I've already seen, like Eric, he gave me one of the TAs. He gave me a list of some real critical tapes that we need to, you know, pay attention to. And I don't know if he said it on a call before, but where is it? I just wrote them down a little while ago. I can't even find them now. Well, anyway, they're somewhere around here, but
the ones we talked about, special deposit, the ones we talked about, general versus special, the other ones we talked about, how to revoke the guardian-ward relationship, just specific topics like that.
Yeah, basically, and he gave me about 8 or 9 of them, to tell you the truth. Maybe he'll come on and you know, tell everybody those specific ones, because Eric, he's been very, very good with picking out specific tapes for us to listen to, and he presses it to you, and he makes you listen to it. Like, listen, guys, we need to listen to this right here, and it's da-da-da, such and such. So I think that's great, actually.
Like I said before, I'm not slowing down, back. It's up to you guys to put the material together, and that's the way it is.
That's right. Well, I say one thing. There's a good couple of the ambassadors that actually have things going on right now. You know what I mean? And it's been really hard to dedicate the time to be able to, you know, chat with people within the groups when you have your own personal situations pressing you. But like me, myself, I can only speak for myself. When I have the time to do it, I will definitely get into the call group and see if there are any questions that I might be able to answer, or, you know, just to build with the people and talk with everybody that's in there. But I tell you, things going on. And, you know, patience. Patience is a virtue with everyone. So, man.
But I tell you what, patience, that's the virtue. Patience.
Yes, patience is a virtue. So that's what it's all about right there. So
you may have a pressing problem, but, hey, I'm only one person.
Yeah, exactly.
Where's the rest of everybody at?
Yeah. I could totally agree with that. Totally agree. But I tell you one thing. It's good, though, because the basic model is there. It's been outlined, and you've done a great job reiterating and re-expressing the basics, and we do back you up. We do speak of the basics also, and people got to put their first foot forward also.
Yeah. So
and take the time with it.
going over the same thing for the 500th time, which is the basics of what NTT is. You know, we just had a couple sheets of paper that tell you how to get there. You know.
Yeah.
Don't have the couple of sheets of paper yet, so that's what we got to create, and that takes some manpower.
Sure does. Sure does. Well, I say one thing. There's a lot of good energy that's circulating around NTT, and if it's something that needs to get done, then it will get done.
So
that's just the way I see it.
Transcript, you know, contact Faith to Trust. Because everything has to be correlated from a central point. You know, otherwise we're spinning our wheels on certain things. We don't want things that are already being created.
Right.
And it all has to be gone through in a central point. So
right.
She's got tapes out there that people are transcribing, and she's taking care of it. So.
Okay, so now let me ask this question then. Do you think people learn better by reading than listening to an audio? Because even when we transcribe, or if one was to transcribe the audio, I mean, I've come across more people who would actually rather look at something visually or listen to it, you know, through an auditory function than to have to sit down and actually read. To tell you the truth, very few people like
Hilbert's original book. There are all kinds of graphs and visual aids in there.
That's what I was saying earlier. That's what I was saying earlier. But I don't know. I guess it would seem that, you know, one would want to sit down and listen to the audio over and over and over and over and again because it's easier to absorb. At least I would think so. It's just strictly my opinion here. Probably there are people who can't listen to an audio or would rather read it. It seems to be more people like that than people who would rather listen to the audio because people want these transcripts. That's what it seems like.
Yeah, you didn't see Jesus on the Serpent on the Mount pull out his PowerPoint and give you a presentation.
I hear that. Well, however a person learns, if that's what the people need, then we'll get it to them. Like you said, it's just going to take a lot of manpower.
Yeah, and you can't rely on me because I can't do it.
No, you're doing your job already.
I don't have time to do it. Can't do it. We're going forward. I'm going forward. I'm not taking the time to slow down.
Well, I tell you one thing. I'm going forward with you. Sounds good to me. Because I got to keep up myself. Definitely. But each one teach one, and I'm a firm believer in that, and I just love doing this stuff. The reason why I want to move forward and keep myself cutting edge in the cutting edge realm of what's going on is because I need to be able to turn around and deliver it correctly to the people.
Freely give as you have freely received.
Right. And, you know, I have people around me that really look to me for answers when it comes to certain things, and I don't like to not have the answers, although I know I'm never going to have all of the answers, but, you know,
you guys got to give me a break. Hey, this stuff's all free for nothing.
Yeah.
What do you expect for free?
Yeah.
You expecting miracles with PowerPoint presentations and slides and this and that and everything? Hey, well, I'm going to have to start charging you guys. I'll go hire somebody to do it if you want it.
Mm-hmm.
Then I'll hear them complain about, hey, you're charging now.
Yeah. That would be the next thing. Well, like I said, we'll get everything done. We'll do what needs to get done, but people need to step up also, put their best foot forward, and we all do it together.
Okay, great. We'll just keep on whittling away at the mountain, one bucket at a time.
Well, we got to work smarter, not harder.
Well, we'll get the excavator in there with the 150-ton rock trucks then.
Something. We need something. All right, well, I think that's it. Is there anybody else on the board right now?
Yeah. Mm-hmm.
All right, cool. Well, I'll let somebody come in who got some questions also. Appreciate you talking to me, Christian. It's always a pleasure.
Okay, Marshall. Appreciate it.
All right.
Jacob, you're unmuted.
Hello?
Yes.
Oh, hi, Christian.
On the air.
How you doing?
Good.
I have a question about the extinguishment phase with the res given to the beneficiary in an order. And once that res is given to the beneficiary, are we able to use that to create it into an instrument?
Once the res is given to the beneficiary, so the trustee did a disbursement and a payment, and now the beneficiary's got the asset?
Mm-hmm.
Okay. And now what was the question again?
Can we use that to create an instrument?
Yeah, you could. You could put it back in trust and use the trust, lock it up in trust for another equitable round. You could have a letter of credit drawn on that or some kind of other instrument. I'm assuming you're talking about it like another debtor creditor instrument. Yeah.
No. Not a debtor creditor. Actually, maybe an instrument held in private by a private entity.
Sure, there's no limit what you could do in the private. All you got to do is get the other party in agreement.
Mm-hmm. Well, do you have to have the party in an agreement? You could actually just, once you have it privately held as a private instrument, you can do with it as you wish, couldn't you?
Yeah, but if it involves another party, that party has to be with you in some way. So there's got to be an agreement.
Oh, the party wouldn't be a man. The party would be possibly an institution that
well,
just
then
kept.
That tells me you might be commingling because now you're talking about corporations and fictions again.
No, more like, let's say, a private trust account.
Okay, what are you thinking about? What are you thinking you're going to try with?
Well, I'm just thinking that you could maybe use that if sort of as enforcement, Christian. Use it in the private for enforcement in whatever manner that you can do so.
Okay, I don't see your point, but...
Well, I guess the point would be to strengthen our position in the private with the extinguishment factor. Instead of having to come at them in the public, come at them in the private. If they weren't going to do anything with that instrument, then we do something with the instrument in the private.
Sure, because you always got the power to extinguish whatever they've got, yeah. And when you extinguish it, it's terminated, it's gone. It doesn't exist.
Now, let's say that were the case, then now back out in the public, what would we have to do to convey that?
Convey that meeting or?
Convey that event. What would we have?
You have to have a record that you could do that, and you have done it because that's what they'd be fearful of.
Okay, now if you
scared of sword rattlers, I think they're scared of people who have used the sword.
But back out in the very beginning, where you had your 1003, and you were in cahoots with the MB, the mortgage broker. Is that not where the implied power of attorney would crop up? There's an implied power of attorney, isn't there?
Yes.
And where does it come from?
From the grantor, you sign it, or you implied it.
But did you not imply it through the mortgage contract?
Yeah.
Prior to the grantor trust. Okay. So the question I have about that is, if the mortgage broker went out of business, is the empowered power of attorney gone?
Yeah.
Was that affirmative?
Yeah, the right would be gone unless he's passed on the right and it went with the mortgage. Because the mortgage, even though the entity has ceased, the mortgage and everything, the note and everything still exists, and probably all the documentation and implied contracts with it.
Okay. Makes sense. Okay. And then let's say, everything gets convoluted down the line, and you've got all this stuff flying and going on, and because of that, not much was done in the proper order. So let's say you get down the line and you got somebody that's coming at you in a mortgage situation, and I don't know, when you speak a lot, because you're in a judicial state, a lot of your statements are geared towards judicial statements, right?
Yeah, but that doesn't hold me back in a non-judicial state, because I can put them in a judicial position right off the bat.
Okay. So let's say we're in a non-judicial or judicial, doesn't matter, but let's say that the party that's coming at us there's a party coming at us, and the party's the plaintiff, as opposed to we're coming at them and we're the defendant, okay?
Yeah, that's the problem. See, nobody comes at them. They allow them to complete this transaction without a judicial hearing. That's a big mistake.
Well, also people, I don't think, are going after the proper parties, because you've got this original beneficiary that's an alleged lender, and then he hands the ball off. It's like a football game. Hands the ball off to the halfback. He's coming around. He wants to, send that off to the end. And so you have
all these parties under the heading, and just keep on adding them as additional parties on the complaint. Join them all in.
Okay. Well, in that quarterback halfback in, yes. But let's say now you have a new defensive back comes into play, and that's a new trustee. And he really doesn't have he's not done his due diligence, doesn't really know where his stance is, and neither does the parties, because they don't know what's going on, because it's so convoluted, there's so many parties involved. But let's say that, that party that's coming at you doesn't have any standing, and that's eventually
just to the judge, look at all these parties that I had to join in here. I want to know which one of these parties I owe.
Yeah, but let's say there's three parties that are pretty definitive. They are the alleged lender, who has now become the certificate holder, and there is the third party debt collector, and there is the alleged trustee, who's really not even a trustee, but you just think he is. But what about if you're in a non-judicial or judicial, I guess either way, let's say there's a case and there's a plaintiff coming at you, or you come up with a case against whomever it might be. But let's say, let's do a hypothetical. Let's say there's a holder in due course that's coming at you, and he is hiding, behind a third-party debt collector who is fronted by a trustee foreclosure attorney. Okay, and so
is he known?
Is what?
Is he unknown?
He's known, and he's coming at you. He's foreclosing. The trustee is foreclosing.
So he's a holder in due course, you said?
No. I said there's three parties. The holder in due course. This is hypothetical. There's a third-party debt collector, a servicing agent, and then there's a trustee.
So the holder in due course is not known?
I'd say in most people's cases, it's not. In my case, it is. In this hypothetical case, it would be known. Of course you'd know it. But the point is that you got the holder in due course, being fronted by this third-party debt collector who's hiring a trustee. Now, if I wanted to bring a case against the trustee for whatever reasons, and I have a case coming at me,
well, whoever the party is, it's really simple. Make them prove holder in due course status. That'll get right down to the chase. If they can't prove that they're holder in due course, then, hey, case dismissed.
Well, that's true. But what I'm trying to do is see if I can't create a trust with a case number against the trustee that would hold equal weight to the case of the trust res of the case of them coming at me.
Well, that's kind of like what NTT is all about. We're just creating an asset that we're going to do a merger and extinguish the debt.
Right. So in this hypothetical case, we have a debt collector with a beneficiary, let's say, that's got a case coming against us. And we bring a case against the trustee because he's got umpteen violations. So now we have an equal case. Could I use the case that I bring against the trustee? Could I turn that into trust res and merge that title with the case res of the party that's coming at me in the public side?
Yeah, you take the lower estate and merge it in with the higher estate.
Well, which would be the lower and higher in that case? The trustee would be the lower, and the holder would be the higher.
I'd have to think about that, but I would merge the two together.
Okay. Okay, well, thanks a lot, Christian. That's very helpful. I appreciate it.
All right. Who's next?
Hey, Christian. I had a quick question. Because you were talking about earlier about paying the debt and everything. Question: let's say if there was a foreclosure, this is to a party I know. There was a foreclosure. It actually happened 5 years ago. Now he's petitioned twice to the court to receive the note back, and they're just not answering. They're not even addressing the issue. The thing was on the Experian report was real interesting because it even showed the status. It said paid and closed right on the Experian report. So the thing is, I'm assuming that entire debt is totally relinquished, but he's still entitled to his note and interest and everything else that was related to that.
Yeah.
But I found that very interesting because now typically when you're bringing it into the private, that's where also under the indenture you're requesting for all accounting from day one to the end, to either the payment date or the foreclosure date, to exactly what happened in the transaction, in the entire transaction history. Is that correct?
Yeah, you could ask for that. Yeah.
And this way, because typically, you see, the thing is that where most people err, especially during foreclosure proceedings, if they don't answer the complaint timely, normally that puts them in a default category. And once they get a judgment against them, there's where they're barred from actually going and asking for the discovery. All types of discovery or interrogatories relating to them, so it puts them right behind the eight ball. And I'm thinking once you're bringing it into the private and creating and claiming and changing titles, that could also be a part of the trustee's duty for full accounting regarding this.
Yeah, it's his duty to give you a statement of accounting and account where all the trust res and transactions that he did when he had trust res.
Right. You see, because the thing is, like
he asked for it.
Right. Now, also too, there are you can also ask if there were any insurance proceeds paid out in the event of a default or at any time during the life of the secured instrument and the mortgage note, can't you? Requesting a history of the any type of insurance payout?
Sure. But if you do this all under trust, now you got them under a breach of trust. Now you got some power to come back at them.
So then this way, and really it's a back door to get discovery. If you didn't do it timely in the first bite.
Yeah, because as a beneficiary, you just make the prima facie case. That trustee's presumed to be guilty, and now you got him. Now you come in with the tracing order and the stay on the action and a freezing of the trustee's assets and finding out whether he commingled it or not, what happened to it, where it is. He never came up with a statement of accounting. It's just a question of, do we understand how to enforce it?
Right. It's kind of like finding your dad's gun. So, but if you know how to shoot, you could be dangerous.
Yeah, that's right.
Yeah. Okay. All right. That was a question that I had because it was interesting because this even showed on it. On this Experian, it said paid and closed.
So under debtor creditor, they have no way under contract that they're supposed to respond to you, or do they have to? Under trust, that's a different story because now they owe a duty to the beneficiary to account.
Right. So typically is when you're setting it up and you're doing your UCC1. Now, when you get to the part of doing UCC1 and your threes, you also want to include an indenture.
Indenture, yeah.
Indenture with the entrustee what to do. Is there anything else that we also should be thinking about as far as including?
Well, there's when you might do a review on the Gilbert's where it talks about the trustee's liabilities or duties.
Okay, Gilbert's.
Yeah, that goes in pretty in depth of everything that the trustee's liable for and has a duty to perform. Okay. It talks about accounting as a big thing.
Yeah, and God, you could even hit them on the GAAP accounting, and
whatever
actually
you
even
give instructions to do according to the trust. That's the law of the trust.
Yeah, and you can even find out if they actually even loaned you money or not. If they didn't and just basically loaned you credit, now you got them on a violation of the National Bank Act of 1874.
Yeah. Go get them.
All right. Thanks, bud.
All right.
Bye.
Eric, you're unmuted.
Good evening.
Hi, Eric.
Christian, I was going back to our wonderful foundational book, Gilbert's, and on page 258 of Power of Beneficiaries to modify or terminate. I was looking at this, and there's some things that just jump out clear as day to me, and something resonated within the first page of this that you've been talking about recently, that you've been doing with CJS, and that's looking at it through the eyes of separating it into general and special. And under power for beneficiaries to modify or terminate, we have the reference to the special and the reference to the general. If you'll allow me, I'll read them, and then we can have some discussion, and we can maybe look at how some of the things that everybody's been talking about tonight, how as beneficiaries we can utilize our right to take, and get a better idea of how from that position we really have quite a bit of power.
Okay.
All right. It says, when may all beneficiaries join to modify or terminate? Under subsection 953, page 258, it says, absent a special grant of power to one or more of beneficiaries in England and a few American jurisdictions, has been held that if all the beneficiaries of a trust are legally competent, sui juris, and all consent, they can compel termination or modification of the trust, even if the settler's purpose would thereby be defeated. Well, there's two things that jump out at me here. One of them is a special grant.
Mm-hmm. Right.
That's just consistent with what we've been talking about all along. They're talking about a private situation. This is not something that comes under the at-law side of things. And that's exactly what they mean when they say special grant. So even though Gilbert's is the black, and is it Novus University that uses it?
Nova University.
Nova University that uses it to teach, even though they do. And, of course, they want to teach all the black at the university because that's where they figure most of the people are going to be practicing after they graduate. It still doesn't mean that – I don't think it's possible to talk about trust without looking at both the black and the white of it. So when if there's no special grant, then I guess it's saying that in England and a few American jurisdictions, it's not being held that people have to be legally competent and all have to consent. Because if there is, legally competent and consent is not an issue. If you flip that, if you look at the mirror of it, would that be a fair statement?
Yeah.
Okay. So this is the way they write this is to back people into a corner to make them feel like, well, I can't function, I can't do things in trust because I'm not legally competent, because that's the way that they've written our whole educational system, and now here out of Gilbert's as well. So we got to read between the lines as you've often suggested.
That says to see Supra section 950.
Okay, so let's go ahead and reference 950, and I'll read it. It says power granted to trustee, beneficiary, or third party to modify or terminate, and the section 950 says only as conferred by trust terms. The trustee only has such power to modify or terminate the trust as is conferred upon him by the trust instrument, expressed or impliedly, or in a case of valid unwritten trust, by its provable terms, which would be the SOI that we've talked about again and again, correct?
Well, that would also be by the live grant or parole evidence. Example would be his testimony.
Okay. Okay, back to being what's provable. Okay. A power to modify or terminate may also be conferred by trust provision on a beneficiary or third party. So that right there is where the rubber meets the road as to how powerful the beneficiary's position really is.
And that's the third.
You dropped out. Say again?
Restatement of the third, section 64.
Oh, there's the reference. Okay, I'm with you. Is that the restatement of trusts?
Yeah, the law and trust, the restatement of the third.
Okay.
Section 64.
But that statement right there really means a lot in everything that we're learning, that the power to modify or terminate may also be conferred by trust provision on a beneficiary or third party. Now, we'll talk about what third party means in a minute. First, I want to focus on just the power that the beneficiary really has, that power may be conferred upon them. And of course, if we're looking at the white, the private, and how that power is conferred, well, it's only conferred upon them by the grantor and nobody else, correct?
By the grantor, that's it. He's the godhead of the whole trust. He's the creator.
So there is no other place that power might be conferred by. No other person, no other entity, nothing. It's by the grantor and no one else, correct?
Unless there's wiggle room for the court to construe it or misconstrue it.
So let's let that be a lesson on how clearly we write our indentures or state our indentures if we're doing it vocally.
Yeah, or better yet, that you can demonstrate your intent by testimony and you know what's what because you know it.
So be a man of few words and powerful orders.
Yes, well, what I could made reference to up there, by its provable terms, by the grantor. So if I didn't write my indenture with such exquisite language that leave it room to be misconstrued, I can still come in, as long as I'm still alive and I know and understand, I can come back in and correct any mistake.
And of course, all the while, knowing that not only can we be grantor, but we can also be beneficiary at the same moment.
Yes.
And so when we go to down on section 953 where it says absent a special grant of power to one or more of the beneficiaries, and then of course based on what is just referenced, in this context, we're only going to have in the private. It's not going to apply. Anything in the outlaw side, it's simply not going to apply because looking at this through the frame of it being private.
Unless you get tricked into arguing the outlaw side.
Unless they trick you into traversing in a case, okay.
Yeah, but that's very easy not to fall into that trap if you understand the difference between the two sides.
Okay. And I think that they go on to expand on that in the next couple of lines because it says in England and a few American jurisdictions it's been held that if all beneficiaries of a trust are legally competent and all consent. Mm-hmm. So you got to consent to get them to traverse for you to traverse in.
Right.
So that's really where the thing that I want to point out about what's right here in Gilbert's, and if everybody will go back and read their Gilbert's and read it line by line and realize that we don't have to consent at all to the outlaw side.
No, if you do, you'll be probably commingling the trust and breaching it yourself.
So for all of those people that got educated in the general education system, you were educated to traverse into the outlaw side so you could make a general deposit so they could have jurisdiction over you. And if you'll go back to listen to
I like to reverse that. I would say that the statutes and codes were created for the purpose of so that you do not breach the trust because you will be punished if you do.
But that's the public trust.
Yeah, well, that's the whole statutes and code scenario.
Right. And that's why we were educated generally to not breach the public trust, but what we're talking about here for us to conduct ourselves with knowledge and understanding is to learn how to be our own attorneys, to be sent here, to be the king, and create our own private relationships.
Yeah, and as long as I don't traverse the two sides and breach the trust, then I don't fall under the statutes and codes.
Of course. And when we read this line here, in England and a few American jurisdictions, it's been held that if all beneficiaries of a trust are legally competent and all consent. Well, before you consent or before you think of not consenting, I suggest you go back and you listen to 517, NTT jurisdiction through relationship to the subject matter, guardian, and ward. And that right there will explain that line that I just read perfectly, and you'll have a very good explanation and understanding of what that really means.
Yeah, if people understand and learn how to administer their trust so they do not breach it and commingle it and cause it to be breached, they will, as Christians, be operating under grace and not under the law. Because the law will be the at-law side, which will get you under the statutes and codes for the breach. But if you're operating under grace, under the equitable side, you don't have anything to worry about from the law.
And again, to teach you all how to do that, everyone, TAs, new people, intermediate, everybody, go back and listen to 517 because it clearly describes what your relationship is through the subject matter and how you can be the subject matter or how you can choose not to be. That is a key.
The ability to choose the right path.
Right. And that recording is key for everyone on that subject. So reading on, and I'm going to catch the time.
You read number 1 in that section, but read 951 also and 952.
Okay. I'm just going to finish the paragraph, then I'll go back and reference them, okay? And all consent. They can compel termination or modification of the trust, even if the settlor's purpose would thereby be defeated. So that only sounds like that would be in the at-law side if the settlor's purpose were to be defeated, because the beneficiaries would have to consent to that, and that'd have to be something that would have to be decided by somebody.
I was making reference to if the settler had made it that it wasn't modifiable.
Okay.
But then the beneficiaries, if they all agreed, could come back in and say, we're going to modify it.
Okay.
Now, I think that's under the third restatement. But on the second restatement, I don't think that the beneficiaries had that right. So they've been making it so that even the trust terms and rules are being, the difference between the second and the third, there's been some changes and things made, and I'm not exactly sure whether I go by some of the changes that have been made, but anyway.
Well, let's just talk about the beneficiary's ability to modify, period. Well, if we go into a court case and we don't have the records, the SOI, to show that we're the beneficiary, well, then if the beneficiary has the right to modify and we're the trustee, then what can we do about it anyway?
Nothing, because you haven't proved that you are the beneficiary.
Exactly. So when I was reading this is exactly what I was thinking about, standing in the at-law side of the court, in the public under general deposit.
Doesn't that sound like what is happening today? You come in there and say certain things and nothing happens? It's because you didn't prove your office.
Precisely.
Meaning that you're beneficiary on a trust that wasn't proven.
Yes, precisely, exactly. So when you're standing in court under general deposit and you haven't proven your position and the judge is sitting there all day long knowing that he represents the beneficiaries.
Yeah, now that's fine if he doesn't challenge you, but if he challenges you, then what are you going to say?
Right. You better have the records. You better be ready to drive that truck to it.
It might be, you might not need to, but if it is challenged, you've got to be able to prove it.
Darn right. So when I was reading this from the position of the power that the beneficiaries have, if they don't traverse into the case and they exercise their right to take and modify if need be, this is the context that I was in when I was reading this as far as the frame of mind. So you suggest that I go back and read 951. So let's see if we can bring that into context. It says power of invasion, a trustee's power to distribute, the power to invade, principal may, so long as properly exercised, cause a trust to terminate.
So a withdrawal is a distribution.
Okay, a withdrawal is a distribution. Okay. So if you're coming in there and they're considering you as trustee and you do the withdrawal, you're doing the withdrawal out of the general, which is the distribution of the res.
And that's going to terminate the trust.
You terminate your relationship in the public right then. Right there it is, everybody in Gilbert's. Number 2, Section 1.
What were we talking about on Saturday?
Huh?
What were we talking about on Saturday?
I wasn't on the call.
Oh, well. That's where we're talking about a case was ordered withdrawn and the case closed down. What happened? Was there a distribution that took place and the trust terminated?
Did they fail to order fail to order extinguishment and distribution?
Well, see, they ordered the withdrawal the plaintiff's case by the defendant. The defendant ordered plaintiff's case withdrawn. Put in an order of withdrawal, notice of withdrawal. Case closed down.
Simply by an order to withdraw.
By that statement there of power of invasion under Section 951 out of Gilbert's, it says that when the trustee's power to distribute, which means, example, power to invade, distribute the principal may, so long as properly exercised, cause a trust to terminate. So distribution by the trustee is really a withdrawal from the principal, and that causes the trust to terminate. And same likened to exactly what happened when we were talking about in those cases on Saturday night. As soon as the plaintiff's case was put in, the defendant put in a notice of withdrawal and the case closed down. So the case was terminated, or the trust was terminated. But now the question is, they might not have gone far enough. Were the assets distributed? So that's what I was making reference to.
And I guess the reference that I want to make for everybody is that this is the very first book that we started with when I started with Christian back in November, and today, August, the middle of August now, we can still refer back to it, and it is still consistent with everything that we're learning and learning more about and seeing this differently every day. So please read it. It's so foundational. One statement, one sentence in there really means everything with the trustee's power to distribute or to the principal, as long as done properly, can terminate. That's what we started talking about with withdrawn. Right there it is. So then as we go on to judicial supervision, section 952 that you suggested I read out, where a trustee exercises a discretionary power to modify, terminate, or to distribute trust funds, his exercise or failure to exercise is subject to review by an appropriate court. Judicial review is thus available for abuse of discretion, which is referenced by Corkery v. Dorsey, 111 NE 795, Mass. 1916. This would also be true if the power granted to a beneficiary or a third party is intended to be held in a fiduciary capacity. I'm going to read that again. This would also be true if the power granted to a beneficiary or third party is intended to be held in a fiduciary capacity. So if the beneficiary were a fiduciary, then the beneficiary would be subject to judicial review. Is that what that really says? That's what I get out of it.
Are you reading 952?
I am, 952, right below the case site, where it says, this would also be true if the power granted to a beneficiary or third party is intended to be held in a fiduciary capacity. So the beneficiary could be held under judicial supervision, is what it sounds like.
Let me read it here. Where a trustee exercises discretionary power to modify, terminate, or distribute, is exercised or failed to exercise is subject to review by an appropriate court. Judicial review is thus available for abuse of discretion in the case site.
And then it says, this would also be true if the power granted to a beneficiary or third party is intended to be held in a fiduciary capacity. So if the beneficiary had a fiduciary capacity, they could also be held for judicial review.
Yeah.
What kind of scenario might a beneficiary be held for a fiduciary capacity? What kind of thing would that be?
Let's say that he had an agency relationship with the trustee, and that might be some kind of fiduciary relationship.
Okay, an agency. All right, I'm with you.
But not a trustee, a co-trustee maybe. But.
Right, an agency relationship where he was, he had a fiduciary responsibility to do something with the trust property, but he didn't have legal title to it.
Yeah, let's say he was given the job of doing the accounting that he was fed, totaling up the figures and stuff,
and he failed to do that on behalf of the trustee under an agency relationship. Then he could be held for judicial review.
Yeah, possibly.
Okay.
That's something off the top of my head, but I don't know if that would be appropriate because that might be, it's a conflict of interest. But anyway, it could possibly be a scenario.
Okay. Then it goes on to say the basis upon which a court may intervene and substitute its judgment for that of the trustee or other fiduciary depends on the terms of the discretion. Ordinarily, the trustee's exercise must be reasonable in light of the standards provided or the purposes of the trust, but if the authority of the trustee is couched in terms as absolute or sole and uncontrolled discretion, although such language is not taken literally, the trustee is apparently required only to act in good faith and for purposes contemplated by the settlor. So if we go back to the beginning of this section, where trustees exercise discretionary power to modify, terminate, or distribute trust funds, they may be subject to an appropriate court, to review by an appropriate court. So if we were to send, if we were to have the SOI, the records to prove that a trust exists and we're now the beneficiary and we name the CEO of the bank as the trustee, that's exactly where that comes in, that trustee, if he fails to apply the rest to the debt title, the asset title to the debt title, or the equitable title to the legal title, then he could be held for judicial review, or she could be held for judicial review.
I would take it a little farther. There's your example for the cause of action.
Okay.
What is it?
Breach.
Oh, look at it again.
You talking about the case site?
Huh?
You talking about the case site? Well, the case site could be a model for the cause of action, right?
Oh, it tells you right there what the cause of action is. Right in front of you. You missed everything. You missed the most important thing.
Well, let me go back. I'm going back.
Yeah, the case site is the example, but what's it about? That was a judicial review. Judicial review of what? What's the cause of action? There's the example.
Well, it says the basis upon which a court may intervene and substitute its judgment for that of the trustees or other fiduciary depends on the terms of the discretion. So the terms of the discretion would be based on the indenture that's given to the trustee.
Yeah, where does the case site start? What's the case?
Corkery versus Dorsey.
All right, now go to the sentence before that.
Judicial review is thus available for abuse of discretion.
Yeah, now what's the cause of action?
Well, abuse of discretion.
There you go.
Would be
cause of action.
Well, there could be a whole list of them, right?
Well, in this judicial review for this discretionary power is the abuse of discretion of the discretionary power by the trustee. That's for judicial review. And the case example is Courtney versus Dorsey.
Well, let's say...
So you make up a discretionary power abuse of discretion in your cause of action for your counter complaint.
So that would be the basis.
Right, that's your cause of action.
Abuse of discretion.
Yeah, he had abuse of discretion to modify, terminate, or distribute the trust funds. Either he failed to exercise it or he exercised it wrongly. And that's subject to review under a judicial review, under a cause of action to invoke the judicial review, and that cause of action being abuse of discretion.
And tell me that just doesn't go on in every case that just about that we would probably encounter if we were to withdraw and then they were just to continue to try and steamroll over us.
Yeah, well, let's just take an example for the credit card company that didn't make your payment, or you didn't see any evidence of a receipt maybe, or they didn't give you the trust res back, and you could hit them for a cause of action being abuse of discretion that they didn't terminate or distribute trust funds appropriately.
I think that's what a lot of people are looking for when it comes to what are we going to do for enforcement? What's our cause of action going to be? I think that that's a pretty good bingo right there as far as to give people kind of a light in the storm, to give them an idea of what type of thing they would be shooting for, as far as something that might cover wherever they fail to apply the asset title to the deed title.
How about that whole list that I put together?
I got that here.
Oh, okay, you going to go over that next?
Well, I will if you'd like for me to. Let me get to the... that one might take me a minute to find, but I know I got it. But there's about 8 or 9 of them I know. I know it's... unfair business practices. Of course, we know antitrust is the big one. And I'm just calling this off the top of my head because it's been a while since I looked at the list. But since we're talking about causes of actions, I'm going to look for a minute.
Everybody's got their book. Turn to page 131. Restraints on alienation, spendthrift, and related trusts.
Well, actually, there's a section on spendthrifts a couple pages beyond that I was going to go into. Section 972 on 262 I was going to, because there's some interesting things on there, too. But
also on page 138 under section 490, since we're on to talking about discretion, so discretionary trust, 490. A discretionary trust is one in which the trustee, say the U.S., is given discretion to make or apply or withhold distributions of income or principal, or both, to or for one or more beneficiaries, whether or not the instrument provides standards for the trustee's guidance. So by prescription, the act of establishing a right, the effect lapse of time in creating and destroying the rights, extension of the title or the right by failure to claim or exercise it over a long period of time, you're going to lose it. That's prescription. That could be the standards, provides standards. That's what they're talking about. They're talking about prescription. That's the standards. So, but, in contrary to that, trustee has discretion whether to withhold or pay. Well, here's the bingo. Withhold, that's withholding. And withholding is on a 1099 OID and a tax-back principle as being the founder of the trust, creator of the trust. But anyway.
And that's off of 131, Christian?
138, section 490, discretionary trust, because that's what we're talking about here. Discretion, judicial supervision on a discretionary power. They're assuming a discretionary trust. Judicial review and a cause of action on abuse of discretion if you think it was used wrongly because they didn't pay my trust obligation, because there's a discretionary trust here. Well, you got a comeback right, and your comeback right is the abuse of discretion because it didn't make the payment. Discretionary trust on section 490, page 138, where the trustee, United States trustee, a bankruptcy, has the right to withhold. In other words, you don't get your payments under debtor creditor paid, and you only have a 10% success rate because of discretionary trust.
Boy, that's a bingo right there.
Because the standard is prescription. You got a workaround. It's been withheld. So you can withholding, that's 1099 OID, and tax it back to the principal on a trust. Or you could come back in on page 131 under the restraints on alienation of the spendthrift and the related trust, and the related trust is the discretionary trust. So in general, 459, 460, unalienable rights as the Declaration of Independence. There's your spendthrift trust. So the Declaration of Independence has unalienable rights granted by God, and creditors are unable to collect, creditors are unable to collect or attach rights, titles, and interests. That's trust. That's your CCI, which is, we're not calling it CCI information, we're just calling it confidential information anymore. So the spendthrift trust, they're unable, through the terms of the trust, say the Declaration of Independence or whatever, and the beneficiary is unable voluntarily or involuntarily to transfer his interest in the trust. And he cannot sell or give away his right to future income or capital, and his creditors are unable to collect or attach such rights. And this type of trust is usually created to provide an interest for the beneficiary that will be secure against his own improvidence. Now you want to see the W.8 Ben Part 3, where you got the national principal contracts, the notional principal contracts, on line 2. But anyway, that would create an estoppel. That's by res judicata, and you want to see Section 475 and compare that to where. And then I give an example down below. It says the settlor to trustee and trust for beneficiary to be paid to beneficiary personally and to no other, whether claiming by beneficiary's authority or otherwise, creates a spendthrift trust.
And for everybody that just heard that, just about every word, go look up and pick that apart piece by piece and learn what he just said, because it was chock full of stuff that's so foundational to everything we're doing. Not that I want to interrupt you when you're on a roll, but do you want to go over those causes of actions that you had mentioned a moment ago?
I was waiting for you to find them.
Yeah, I got them. But I don't want to stop you when you're going. We determined that they were the breach of fiduciary duty, breach of trustee, breach of trust, fraudulent transfer, unfair business practices, which equate to fraud, misrepresentation, and unconscionable acts or practices against consumers, unclean hands, unjust enrichment, which these type of things could create a RICO cause of action. And then there's the creating a monopoly, or otherwise known as antitrust. And then there's commingling funds and conversion.
Okay, what section is that under?
What specifically?
Section E, trust purposes. Page 64 starting. So we start thinking about purposes. You know, the purposes. We got causes of action for the incompletion of the purposes. Trust. Purposes being the rights. That starts on page 64, where the causes of action as against the trust purpose. And you want to see number 2 following forward here under section 227, which is impermissible trust purposes. Impermissible trust purposes, section 222. So, which is really also see antitrust, which is anything against the furtherance of commerce or anything that impedes or monopolizes commerce by a lack of economic competition or economic coercion. And that's what the banks do against you. You got to sign these unconscionable contracts, these debtor-creditor relationships. Could have been expressed in a trust, getting them for antitrust, monopoly. because it was impermissible trust purposes. So occasionally a trust, or more often some provision therein, may be challenged as invalid if it appears. And that falls under contracts too, or colorable contracts. Invalid if it appears that the settler or other party, really, was attempting to accomplish an objective that is illegal and requires the commission of a criminal or a tortuous act by the trustee or other party, really, or would be otherwise be contrary to public policy, but not under equity if you had a private trust, because public policy is at law. So A, fraud on creditors. So this fraud against the settler or beneficiary. So an example of an invalid trust purpose is where the owner of the property transfers it to another in trust for a transfer for the purpose of concealing the property. Isn't that what the banks are doing when they don't give you your money back? To hinder or defraud the transferor's creditors. So the purpose of the statutory trust is to protect commerce, really. And the effect of that is, number one, it says, in the situation, the trust is regarded as a nullity, and the creditors of the settler may reach the property as if the trust did not exist, or set aside the transfer as fraudulent. So, what's the cause of action? Fraudulent transfer. Unfair business practice. Under A, tenancy, B, purchase of products and services, and C, insurance claims, and D, debt collection. Any one of them. And then under unfair business practices are A, fraud, B, misrepresentation, C, unconscionable acts or practices against consumers. We'll continue on under 1 there. It says, compare under a somewhat similar but different principle, a transfer in trust, like an outright transfer, may be a fraudulent conveyance, even though it is not otherwise a nullity or illusionary. That is, even though it is generally for the benefit of others, example, the settler's family, if the transfer is not for adequate consideration, what did you get paid? Adequate consideration, and if the transfer is or is thereby rendered insolvent, or if the transfer was made with intent to hinder or defraud the transferor's creditors.
So when we go to court,
let's put it this, or the true grantor of the property. Let's put it that way.
And how can we be solvent when we go to court and they get our signature when they're trying to get FRNs out of us?
Well, you give it to them. You grant it. If you didn't know you were granting it, you gifted it to them, and then you abandoned it. You formed a trust and abandoned it. And number 2, can settler regain property? Section 229. Suppose no creditors materialized on the transferor was able to force to pay his creditors out of other funds. Will he be permitted to compel the transferee to return the property? A, some cases hold that he cannot. His purpose may be considered to be so improper that he is not entitled to relief in equity. Unclean hands, says. As equity will leave wrongdoers where it finds them. There you go. Equitable maxim right there. Trust will not be enforced, and no constructive or resulting trust imposed under such a rule. Even a dishonest transferee may be allowed to retain the property. Gives a case cite there. So, cause of action here, unclean hands. Also, you could bring in commingling, and commingling under debtor-creditor ties under 9336 under UCC. And also conversion, unjust enrichment down below in B. Other cases hold the determinative factor or whether the intended fraud actually succeeded or involved serious moral turpitude. If one has been hurt, or especially if the offense to policy is not serious, a court may order the return of the property to the transferor or to prevent unjust enrichment of the transferee. So, cause of action, unjust enrichment. And then I would check out under Black's Law Dictionary, see rule of reason. And I would check in where it says it's monopoly and antitrust, and then look up under corpus juris, look up monopoly and antitrust.
You want me to share that with you now? Christian.
And then number 3, distinguish protection of beneficiaries' interests, Section 230. While the settlor cannot employ the trust device to avoid his own creditors, he can employ it to shelter the interest from the beneficiary's creditors. See info sections 460 through 489, where they're talking about spendthrift, discretionary, and protective trusts. But shelter the interest. What is the interest? Well, the interest would be on the side of the debtor-creditor side, public side, being a specific amount, but on the equitable side, in equity, the interest is going to be, it's mine.
Would you like the definition out of Black's Fourth for monopoly?
Go ahead.
It says a privilege or a peculiar advantage vested in one or more persons or companies, consisting in the exclusive right or power to carry on a particular business or trade, manufacture a particular article, or control the sale of the whole supply of a particular commodity. Defined in English law to be a license or privilege allowed by the king for the sole buying and selling, making, working, and using of anything whatsoever, whereby the subject in general is restrained from that liberty of manufacturing or trading which he had before. A monopoly consists of the ownership or control of so large a part of the market supply or output of a given commodity as to stifle competition, restrict the freedom of commerce, and give the monopolist control over prices. Boy, if that don't describe the banks, I don't know what does.
Yeah, but we're the only one who has the rights to be a monopoly because we're the only ones that have the particular rights, the special rights, the exigent circumstances, and we're the only right to do that. They don't.
What else did you say look up in Black's?
We have the monopoly on the substantive rights.
If we know our rights.
Yeah, he who sleeps on his rights has no rights.
What else did you suggest to look up?
I don't remember.
Okay.
But that was all in a trust purpose.
Didn't mean to stop you when he was on a roll, so if you want to tune back into it, I'm good with it.
No, but I think the antitrust is our biggest weapon. And before they breach the trust is when we have probably our greatest power to get them not to breach the trust. We don't want them to get into an abuse of discretion. Withholding the payment when they should have paid it.
I think this is an important subject we kind of need to revisit based on some of the things that we're doing. To take everything like you did tonight and just line it up one after the other, I think is really important.
Well, we have to study this stuff enough that we can, we know what it means, and then we can start putting it together, and then we can start enforcing it, which is really coming back to the basics again. There will be no fine wine before it's time. You take away the time, and you got lousy wine.
And no whining.
Yeah, then you will be whining. Drink that lousy wine, you will be whining. Yes.
Yeah, boy, that's for sure. I wanted to continue on section 954 about the Clafton doctrine to draw the contrast between the special and the prevalent American view.
952.
954.
Okay.
All right. Because I read 953, which was the absent of special grant of power. So then B, Clafton doctrine, or Claflin doctrine, is the majority view, and this makes sense because it's it's the general view. The prevalent American view is somewhat more limiting, which is called the Claflin doctrine, is somewhat more limiting than the English view. Claflin versus Claflin is the case site from 1889. As generally stated, it provides that the beneficiaries can compel termination or modification of a trust if and only if all beneficiaries join in requesting the trustee or petitioning the court to modify or terminate. So trustees have to petition the court. That means they have failed to withdraw the general and redeposit as the special. Right there. That says it right there by petitioning, doesn't it?
Mm-hmm.
All right. And then it says, 2, the proposed modification or the termination will not defeat a material purpose of the settlor in creating the trust res. And that's from the restatement of the second, section 337. It says, but see restatement of the third, 65, section 65, number 2. So I guess you got to look at those two and compare them. Are you familiar with both of those sections, Christian?
No, I'm not. I forgot what they are.
Okay. And it says, note, a modern view based on statute or limited case law is less restrictive in several crucial respects. So the point that I was trying to do there was draw the contrast between special, which is where you have to consent if it's special, compared to the Claflin doctrine, which is generally stated, and you got to petition the court. That was the contrast I was trying to draw and point out. And then on section 972, I picked up something that was pretty interesting. Spendthrift trust. It says, apparently in all cases from Claflin jurisdictions, which would be the general at-law jurisdiction, right? It is held that if a spendthrift restraint is validly imposed on the interest of any beneficiaries, the trust cannot be terminated, even though such provisions are often included routinely by lawyers with no conscious concern having been expressed by the settler client about a beneficiary's imprudence. So everybody take note that if you think you're going to work with an attorney, he's going to include the Claflin doctrine in your trust documentation, and you're going to be right back in the general where you don't want to be. It is possible that courts are simply focusing on the inalienable nature of the interests, and that termination or modification is viewed as a form of alienation, and then it says in parentheses, in exchange. But most cases rely on the apparent protective purpose as a material purpose of the settlor. Christian, what do they mean by an exchange?
What section now?
972. About halfway down the paragraph.
972?
Yeah.
Spendthrift trust?
Right. It says, it's about halfway down the page to the right-hand side. It says it is possible that the courts are simply focusing on the inalienable nature.
Well, that's a transfer or an exchange.
Right. Of the interest, and that termination or modification is viewed as a form of alienation. And then it says an exchange. What do they mean by an exchange? What does that mean?
Negotiation.
Oh.
Transfer.
Public negotiation. Okay.
Alienability is transferability.
Okay. Well, I know alienability is that, but I didn't know what it meant by an exchange.
Exchange is the same thing. That's transfer. Transfer and exchange is the same as alienation.
Being leaned up.
Transferability. Yeah, because when you're leaned up, you've been transferred.
Uh-huh.
Your assets have been transferred.
Okay. All right. So, and then it goes on to say, spendthrift restrictions are not sufficient alone to establish or to create a presumption of a material purpose that would prevent termination. So, termination by the beneficiaries. And then it says, see the UTC. In everything that we're learning, do you think that there's things to be gleaned that'll help us by studying the UTC?
Yeah, because that forms the basic model of that everything came out of.
All right. So,
on a California one, and that's how it all came about.
What kind of things in there would you suggest we look at and learn?
Well, it's pretty simple. It's kind of like the Hague one. Pretty basic. Gives you a good understanding model.
Well, the UTC is quite a bit to read, right?
No.
No? Okay.
No. It's only maybe 10 pages.
Oh, okay. Well, I'm glad I brought that out. Hopefully everybody will get right on that and get some ideas on what the models look like based on that. And then and UTC.
It's comparable to the one that the Hague Convention puts out on the restatement of trust.
So just in those, we could just glean so much as far as just basic models.
And it's based on the California model to start out with. So,
and when you say the California model, give us a little bit of details to give us an idea.
Well, that was the first one that came about, and the one in California, and then it spread, it expanded. Now it's all uniform through all the states.
But the California model, is that the California UTC model? Is that what you're talking about?
Yeah, each state has their own like sub-model, but it's based on the main model, which is UTC. It all started with the California model, but that's how it grew into the national model.
So then what we might be able to do is take that and then look at the different states that we're in and just see how they compare.
They're all governed by the national model, which is basically the same. So it's just like your, UCC. There's a national UCC, but there's one codified in everybody's state, and the codification is almost verbatim for the same thing as the national model.
So maybe that might be one of those foundational things that everybody looks at just to understand when they're thinking about how to model themselves in trust. Go and look at that national model. Look at that California model. Look at their own state model. Mm-hmm. Okay. And then it goes on to say the spendthrift provision not presumed to constitute a material purpose, but this provision is now bracketed, suggesting no uniformity, objection if an adopting state omits it. So in a situation where we are dealing with a bank or a court, do you think that if on their side, is there any spendthrift provisions on the public trust side?
Unless it's spelled out in the indenture, or they're doing abuse of discretion. What was the indenture?
Well, the indenture to the public trust is the statutes, correct?
Yeah, it's, I don't know if there's specific ones, like, there probably are, but yeah.
Well, if you violate the state statutes, then they get you under a debtor-creditor relationship, which is really a trust relationship, so you're really violating the indentures, even though you didn't know you were involved in a trust. That's really what it boils down to, based on what happened back on June 5th, 1933. When they split our titles.
Right, but I think the opposite way of looking at it is better. The statutes and codes are in position there to separate or segregate the two realms and keep them segregated because there is a trust. And if you breach or commingle them, you're liable for the statutes and codes. But that's because you try to put yourself under the law again by going at law and getting a remedy when you should have stayed under grace, under equity, and you would have had no problem.
The mirror of both sides, okay.
Yeah, if I operate in grace, under equity, under trust, I don't need the at-law side. I don't need to be under the law. I'm above the law. Because I don't break the law.
But it's really not the law, it's really public policy.
I don't commingle the other side into the other one. I don't breach it. I'm not liable for the breach. I don't commingle. Therefore, the law has no power on me, no hold on me.
Because you never traversed in, you withdrew your deposit, or you never made a deposit to begin with.
We are living in the democracy under the at-law side. No, we should be living under the republic.
And that's where the grace is in the republic.
Yes. Uh-huh.
But is it, when you say the law, when you break the law, is it really the law or really public policy or really corporate
the
policy?
law is a consequence of you breaching the trust.
Right, but is it really law or is it really policy?
It's set, the public policy is set up, the statutes and codes is set up to protect you from breaching the trust, because if you breach a trust, you get hit. Don't breach a trust, don't get hit by any laws.
So it's really a trust that has developed into a corporation or yeah, that's right, because they had to split the titles and create the debtor-creditor relationship, so they had to do it through contractual relationships. So then they held you under a corporate contractual relationship, and then they get you for breach of contract, which, when it boils down to it, is really breach of trust.
Right. You weren't enforcing a trust, you were doing the debtor-creditor thing. You don't want to be doing the debtor-creditor thing. You put yourself right under the law.
By your own declaration.
The codes there. Because you're breaching. You're breaching your trust.
By your own declaration that you went right into.
Yes, yes. And then you wonder why these people are the courts now. They come and get you and take your assets. We did it all. We ourselves did we hung ourselves.
So when we go back to some of the stuff that I was reading tonight about the power of the beneficiary to modify or terminate, and it says right in the first sentence of Section 953, absent a special grant of power to one or more of the beneficiaries. So if there is a special grant of power, which we could grant to ourselves and claim ourselves as the beneficiary, so that means we would have the right to take, then we can go ahead and withdraw and then out of the general, grant ourselves that special power, and then be the beneficiary and the right to take, and then order the trustee what to do. And if they fail to do it, then we can go ahead and refer back to Section 952 for judicial review.
Yeah, but the question is, would there be any need for a judicial review on any of this stuff if we didn't have business in the public? If we weren't commingling and breaching the trust by doing business?
So then what that goes back to is what we've been talking about for quite a while now with correcting the IMF.
Yeah. There would be no need for court to go into court. There would be no summonses. There would be no tickets, no nothing. But we got to go back. We got to clean up all these things that we've got established in the public that's causing us to continually breach the trust, making us liable for all the statutes and codes all the time.
Otherwise known as AKA public policy.
Yeah.
Corporate policy.
Mm-hmm.
All the way up to the Supreme Court. So I was wondering about how do Article 3 courts apply to this realm of private trust?
What applies to private trust?
Article 3 courts?
Article 3 courts. There's been an Article 3 court in existence since, I think, 1968.
So we don't have to worry about those. Okay. I heard a little while back that there was, I think, one Article 3.
There is a substitute because we're really the true Article 3 court.
You said we are?
We are the true Article 3 court, yes.
You mean you're talking about in chambers, in private?
Well, the IRS is going to enforce their records. And who's the one who puts the things in their file, in their records? Who creates their records? We do.
We do.
So what are you creating the records with? Are you creating the general deposit records? Are you creating the debtor-creditor records? Are you creating the public policy records? Or are you creating the special records? Are you creating the trust records? which records are you creating, general versus special? Because the IRS is going to enforce whichever ones you put in there.
Being a trust themselves, they have that duty as trustee.
They're not the trustee. You are. You self-appointed yourself trustee, and you haven't corrected the record. You're the one that come after for the liability because you are the trustee. You appointed yourself. But that is your true Article 3 court right there, because you got the power to pull yourself right out of court or enforce a court decision based on what you put in the IRS records, because all of the corporate agency entities have to, their records must comport to that IMF, that individual master file out of the IRS that you create. Now, who is the grantor on that account? The creator of that Article 3 court. Who's the one who gives the orders out of that court? You do. There's your true Article 3 court.
So going back to that, there hasn't been an Article 3 court since 1968. What was it in 1968 that made them not popular or not function?
No, the silver certificates on the notes. That was the last of the Republic. That was the last of the Article 3, because your Article 3 court, you have to get a remedy, and you have to get a remedy by getting paid. And if you can't get paid, you got no Article 3 court. Got no common law, got no Republic.
Is that remedy or relief?
Court is being held in trust just with everything else on the Republic side. Still there. It's just being held in trust.
Is that remedy? You can't get a remedy, or you can't get relief?
Well, it was remedy before, when there was money. But now you can't get a remedy because there is no money. So you got to get relief.
Since 68.
They took out the gold in 33. They changed the courts around in 1938, Erie versus Tompkins. 68 or 65 are in there whenever they took the gold out. That was silver out. That was the last. That was the capstone on the coffin. You're now totally trusted up.
But today we can bring back the Article 3 court simply by creating the proper records.
In the IRS, yes.
Well, can we actually do it on an individual case basis?
Sure, I believe so.
Okay.
Look at the Form 56. Last part.
I don't have it in front of me, so if you'll let us know what that is.
Let's talk about appointment. Talks about the last part there where talks about a court, I believe. You're putting in a court or case or something in there. There's your individual case by case.
So I guess I'll be reviewing that and bringing up some questions, maybe how to utilize that for any cases that might come up, and that would work for both criminal or civil, right? Because it's all in commerce.
Quite possibly, but I don't know if I'd want to use their Form 56 like the W-8 Ben. You got to use a modified form.
Okay. Create your own because you're the creator anyways.
Yeah. What do I need their form for? They need a form that they can see, so I'll look at it and see whether or not we could use it, but I don't know if really we want to use it, so without maybe modifying it.
Yeah, once you have that SOI, you better be able to be the king and create your own realm in every aspect, huh? So do you think that if you were to use the 56, you might be viewed as commingling?
Possibly. I would want to restudy those forms again with more trust eyes now than before when I was looking at it more under debtor-creditor.
You're talking about the Ben and the IMY and the...
Not so much the Ben. Yeah, the modified Ben form's okay in the IMY, but the other IRS forms, I would have to look at those again. 28, 90, 91s, those others.
I heard 28, 90, 90, and 91s, and what else?
Form 56 and any others that we would use. The OIDs.
And the OID makes perfect sense because once we switch over the IMF, once we correct the IMF, well, then we can issue the document. But before we were doing it as trustees when we had no right to take.
The 1099s quite possibly might be the way we want to manipulate some of these records under trust, but we haven't gotten that far yet. So.
But I mean, before Trust Eyes, before all this came along, it made perfect sense as to why they were hammering people doing the 1099 OIDs, because they were doing it as trustees and they had no right to take, only the legal liability to make the payment. So of course the IRS couldn't let them do that because they didn't have the right. They didn't have the records to prove it.
Yeah, that's probably so. They hadn't claimed improved trust first in order to be able to officiate the office of, say, trustee or anything other than trustee.
Or if they had claimed improved trust, then they could have been the grantor and the beneficiary and then ordered the agent to be the trustee and make the payment.
Yeah, because if you wanted to order it back to the principal on a trust, the principal would winds up being the beneficiary. So you're a trustee on the trust, and you're trying to get it as beneficiary. There's a conflict there.
Yeah, it sounds like the conflict could be that you could be terminating it, right? You're trying to get a distribution.
Well, I don't know if you're merging the rights, because that would terminate the trust, but you may be trying to merge the proceeds in a way.
Which would certainly show that you're not competent.
Yes, absolutely. And then you're liable for the statutes and codes because you breached your own trust again.
Okay. Go right back.
Equity, you were operating in that long.
Go right back to what we've been talking about foundationally all this time.
Yeah, you didn't know how to administer the trust properly.
Well, Christian, I could keep reading out of Gilbert's. I don't know. Do you have other people waiting to talk?
I don't know. Got one more, I guess.
All right. Thanks so much. I appreciate it.
Okay. Thanks, Eric.
Yep.
Appreciate your work, too.
Yep. Thank you.
Hello?
Ira.
Yes. Hi, Christian. Long time no hear from.
Yeah, how you been?
Pretty good. Can't complain. Well, I just wanted to say directly to you, thank you, thank you, thank you. I've won, for a friend of mine, I've assisted her and won my first foreclosure case. And we used a lot of different strategies, including expressing the trust from the very beginning, never referring to ourselves as defendants, constantly referring to ourselves as the grantor beneficiary, using all the New York State UCC statutes to prove that we are the creators of the fund. And we basically won the case, and we found out from another friend of mine who had the same judge who received a decision the same day that we got ours, but his was not favorable. He had done some research to find that this was a retired appellate court judge who moved to a lower state court after his retirement, and he was reviewing his decisions, and he found that he never, ever, he had no history of ruling in favor of the defendant. So, though we didn't go into the private side of the equity, I guess we would have, you could call it, we went to the public side, because we did this in the public, and we were very successful. We didn't get everything that, I had asked for in this dismissal, including with prejudice, the release of lien, etc., but we did receive a dismissal without prejudice, and we're going to try to, close the case by getting a quiet title to release the lien. because the mortgage company is now defunct, and they're the only people that have the lien on the property. But, I attribute a lot of our success through the information that you shared for the last 2 years, to everyone for free. And I really want to thank you very much, you and Lisa.
I appreciate that a whole lot. Thank you.
So it's a success story that we are attributing it to NTT, along with several other strategies that we use. And I think another strategy that was successful was we gave the opposing attorney 10 days to produce the original note, or we would contact, which we included as exhibits, post-dated, do a complaint with FinCEN, FinCEN, Control of the Currency, a couple other agencies, and most importantly, do a 3949A. And I believe the judge realized that, he had a choice there to either throw the opposing attorney under the bus, or we would throw him under the bus next if he didn't do the right thing. But those two strategies were crucial in the success of the foreclosure. And, I'm very grateful and appreciative, and wanted to definitely say thank you. I sent an email, a message through the group, Skype conference group, and, I can't say thank you enough.
I'll have to go back on and read it. I haven't read it yet, so.
Okay, I sent it a couple of days ago.
Well, that's great. Everybody out there, NTT works, so.
Yes.
How many hours do you think you've spent on it?
Oh, my God. It started last September, so, I down about 3 hours sleep a night, maybe 8 hours a day, roughly, give or take, But it was a lot. It's a lot. Answering the response, putting together a strategy. We did an SEC FOIA request, which was crucial. We have a letter from, which I sent through the group as well, what the letter looks like, from Larry Mills, who's the record officer, and signed by the secretary, stating that so-and-so bank, that they had no records of them, putting in the required forms for security. And we have that as a testation. We have a gold seal, blue ribbon, dual signatures. And now today I just received a link to the SEC for the enforcement and complaint. So now we're going to send a copy of the response that we got from the records officer and, document the complaint that they did the illegal conversion of the negotiable instrument into a security, and none of the documents that they were supposed to file with the SEC is on record with the SEC.
Did you use Edgar to do the lookup of the loan?
No.
No, you didn't?
No, we just did a FOIA request with the SEC. We asked them a series of questions, the 424 and all those type questions.
I was looking for somebody who could explain how to use the Edgar.
The Edgar is too confusing. I tried, and I just had no patience for that.
Yeah, because we were trying to look up a loan and see whether or not they had securitized it, put it into trust, and we needed somebody who had some experience as to could show and see where to look and track it down.
No. I have a contact who is able to get the QSIS, but it's very expensive. But they do give you an entire report, the name of the number of the account that it's in, how much is in the account, but it's very expensive. but that's something we're going to do down the line if they decide to, open another case for damages. Right now, we just want to get a clear title.
So how long were you involved with this case? How long did it take?
From September of last year until 27th of July, when we got the decision, which for, New York State, Nassau County in particular, that's a short period of time. We didn't have to go to trial. My friend never had to show up in court. We just basically went back and forth with the attorneys. We answered the complaint. They responded. We responded to them. From the very beginning, we expressed the trust. We showed through the codes how we created the funding. We, exposed the whole, corruption of the entire process, the securitization, the MERS. It was a MERS case. We quoted from MERS website, which states the limitations of MERS. And now I'm told that whole statement from the MERS website has been removed that we quoted in our case.
They basically hung themselves in their own corruptness.
Yes, we threw everything at them but the kitchen sink. And the good thing is we still had strategy left that we didn't even use.
So what's the next step? What are you going to do? You're going to do a quiet title action?
Well, Lisa gave me a very great suggestion to just open a new index number with the defunct bank. Well, they're not a bank, a mortgage company. That's my second step. My first step, since they're not a bank and under the FDIC, because the FDIC, in case people didn't know, they will provide a release of lien under certain circumstances if it's a bank. And if it's not a bank, they're under the supervision of thrift supervision under the Treasury. So we're going to send them a copy of the judgment and ask if they can send us a release of lien. If they can do that, we'll just go to the county and remove the lien, and she'll have the property free and clear. Then I'm suggesting that she change the title twice, one to a relative and then into a private trust, and then put a land patent on it.
Mm-hmm.
How does that sound to you?
Yeah, that's doable. Because once you terminate the trust, then you can bring the land patent forward and perfect that by putting the new owners on it.
So if we can get the release of lien, would you recommend doing the UCCs, the moving titles? Is that still necessary in your opinion?
Yeah, I would get it out of the present owner's name, put it in some kind of asset protection device, either put it in another trust or something, or get it in a position where they can't attach it again.
Right, but the first UCC would be from who to who, since the company no longer exists. And the people that came after us, they lost the case. So who would you do the UCC between?
The people that I did business with on the first, even though they're not in existence, they never will answer.
Okay.
I don't know who took it over, so all I got to do is make a public notice, and within 30 days, a public notice is going to stand.
Okay, and then do the UCC one between Lend America and my friend, and then from my friend to a trust.
Yeah, I would get it out.
Okay, now if we don't get a release of lien, do you think that process would still be valid?
Quiet title action? Yeah.
Okay.
Quiet title action with the lender there, even though they're defunct, they will not show up, so you'll default automatically from them and go for the reconveyance.
Now, the reconveyance that...
the release of the lien.
Oh, okay. Okay, and hopefully we won't have too much trouble at the county, which I'm expecting that we will.
No, not with the judge's order of a release of a lien.
Well, he didn't give us that. He just gave us a dismissal without prejudice.
Did you ask for it?
Yes, I did. I asked for release of lien, certificate of satisfaction to the 3 reporting agencies, damages valued at the property, the value of the property. Oh, I asked for the whole.
I want to try this. Go in with a order for release of lien and see if he'll sign the order.
Oh.
It might be the fact that you didn't put in an order for a release of lien for him to sign.
I did. It was in my dismissal.
Okay.
My dismissal was probably a little overkill. It was 24 pages, but, he knew exactly this guy doesn't give anybody anything.
Uh-huh.
Well, the fact that we got that is considered a major win.
Well, maybe a new case action on a quiet title, but maybe you might get a different judge this time, and then.
Right. Well, Lisa suggested in the new action, go after the defunct mortgage company.
Uh-huh.
So we should be able to get a default judgment when no one shows up.
Right. And then get a release that way.
Right.
That'd be an automatic win, and then there's no reason why the judge shouldn't sign the release order.
True. Yeah, so that's where we're at. But we, definitely see it as a major success, and we definitely feel that, NTT had a lot to do with it. So, Harold was stating that in New York they've merged at law and equity into one. How is that possible?
It's like it's supposed to be all in one form. You can get equity and at law in the same court.
Okay, so would you say that's what happened with my case?
Well, I'm not too familiar with the stuff that you put in.
Well,
we're more or less operating more on the equitable side. Sounds like you might have had some of the debtor creditor stuff in there, but because you're asking.
Not really.
No.
Because the statement that you put in the footnote and that grantor, beneficiary, now coming forward and state, that whole language.
Mm-hmm,
that
right.
you used in the case that was going to sale. You know what I'm talking about? Let me pull it up.
Yeah, I remember.
Right. Well, that's the language that we used.
Right.
From the beginning, and that clearly is equity language. Am I correct?
That is, yeah.
We didn't do the in-chamber hearing or put a protective order on the documents because my friend didn't feel that she could handle all that.
Uh-huh.
So we just had our war through paperwork.
So we've kind of geared up a little more on, there's no adequate remedy at law, and we're coming in now with no claims on the at-law side at all, and solely under equity.
Wow.
And we're just asking for relief instead of remedy.
Okay.
Relief under equity for a breach of rights.
Wow. Boy, I've been out the loop. I've lost track of you since February.
Yeah.
So you wouldn't know offhand any call where you're dealing with that specifically?
Yeah. I don't know what the date is, though.
For the name?
You might want to get a hold of Eric off the chat there, and he might be able to Skype that over to you. Or maybe, I don't know. Do we have a list of the the show we were talking about the, let's see, what ones? The equity ones. Forget what those dates were.
Christian, which equity?
We did the 30A in corpus juris secundum.
I got it right here. Stand by.
Oh, thank you.
It's going to be 629.
Okay, thank you.
There were about
4 or 5.
5 shows in there.
Yeah, but there's going to be 4 or 5 of those. Yeah. So if I was you, I'd go probably back to the. I'd go back to the first. Actually, it looks like it's looking like maybe 5:30, 5:31, 6:1, and I might have the dates not perfect, but it's right in there because that was Memorial Day weekend. So I know there's a Sunday and a Monday, and then it looks like 6:12 because it said equity continued there. So pretty much the end of May and the month of June, I'd be listening.
Okay, thank you.
And we spent quite a while on equity, how to get in a court of equity.
Now, would that be a challenge for me because they've merged, supposedly merged at law and equity in the state of New York?
Well, really what they did is they say they merged them, but you've got a statutory equity and you've got a private side equity, and they're both there. But to get into the private side equity, there's where you got to go in through in chambers to get that.
Right, in which we weren't, I could probably have done it.
Yeah. And what we do is we don't claim any adequate remedies at law. And we don't claim any at-law stuff at all. So therefore, we can't get a remedy because we're not asking for a remedy because we're saying that there's none exist. So that means we have to get a relief instead of a remedy, and relief is an equity, and that's the private side equity. And we use solely just the maxims. We don't use any statutes and codes or any statutory equivalents of the equitable maxims. We just use the equity maxims. And we put in there, there's some switches in there. We put in there that we're signed by grantor beneficiary, and then we put in there that this hearing is contrary to equity, and 3, this trust is a special matter, because we're pleading special matters, that's equity, and 4, then, as there exists, quote, no adequate remedy at law, that's direct quote right out of corpus juris secundum, and 5, I invoke the private side of equity for relief, and those are like switches that kind of throws it into the equity position.
Wow.
But be prepared. They're going to make you prove trust, so make sure that judge can make a determination.
Why he has to have a particular standing?
Right back to page.
The standing will be they don't have a standing.
Right. So how do I can't give him a standing.
Yeah. Well, what we're doing is we're claiming solely just rights. So we're coming in and say, okay, we have a right to possession that's being breached. We have a right to property that's being breached. We have a right to real property. So it's all about rights, and these are all special. And if we claim a right that's being taken from us, then that's equitable.
Okay.
And then the maxims come into play then.
But at that point, you're going to have to make sure the judge can make a determination of trust, and that goes right back to page 1 of Gilbert's.
Okay. Thank you.
That's when your real test of all NTT is going to come at that moment.
Oh, okay. Oh, I'm not worried. It's my friend that, I don't think she'll be able to do it. So she was practically had a nervous breakdown when she thought she had to go into court.
Wow. Most people do.
I know.
Well, I'm working with somebody right now who didn't have the proper information. The judge could not make a determination of trust, and they rolled over them. And also remember that there's the three-strike rule, and they may test you 3 times to make sure that you're going to state those 5 statements 3 times in a row so it's on the record, so they know that you're convicted in your agenda.
Okay, meaning the criteria of what forms a trust.
Of what Christian just stated, they may make you state those 5 statements 3 times in a row.
Okay.
Some judges might take it after the first time, but if they go, well, that's okay, but we're still going to go on with the case, well, then you go right back to your 5 statements, and whatever they say, you go and do it again, because some judges will make you state it 3 times.
Oh my God! Wait, what are the 5 statements, please?
Contact me. I sent you an IM, so I'll share them with you.
Thank you. And wait, this is Eric, correct?
It is.
Okay.
And we're working on the ultimate, as when the case comes into existence against the defendant being the grantor comes in and withdraws the case and closes the case down.
Wow. Well, I have a lot of catching up to do, I see. Wow. God, you guys have been at warp speed since February, huh?
Yeah, we have.
But you can only retain so much so fast, so don't worry. It's all there.
Okay, good.
Learn it at your pace. You have time.
Okay, I guess he sensed my sense of overwhelmness.
Don't let it overwhelm you. As Christian told me, every harvest takes a season.
True.
And you can't rush it. It's only going to be ripe and perfect when it's ripe and perfect.
True.
But you have had a success, so you now it's time to continue to employ this and just know that once you get past that judge testing you, which is going to be that most challenging moment, and even if they don't let you through at that moment, you can always go back and ask for an amendment of the pleading.
Okay.
Put in a motion to amend the pleading.
Okay. I don't know how far that would work, though.
Well, she could at least make the motion.
But what would I amend it to when I'm hoping to put my best foot forward in the initial pleading?
Well, everybody does, but in case you don't, then you can come back and ask questions and say, what did I do wrong? What should I amend?
She already got a win. That's the thing.
Right.
What's she going to amend?
No, I don't mean on that. I'm talking about anything in the future.
Oh, okay.
Right, because I was a little nervous about amending the judgment because I don't want to give room for them to, recontract or something like that.
I wasn't suggesting that at all, but
right.
I think the quiet title action against the original party that's defunct, they're not going to show up, that you're going to get the default anyway.
Okay. Or hoping that trust supervision, since they supervise brokerage mortgage lenders, hopefully they'll be able to give it to me. If FDIC can give it to banks, why can't they?
Well, that'd be a great piece of research for you to learn and bring back to us. We'd love to know that. That'd be great to know.
Well, using NTT, you should be able to order the lifting of the lien.
Right, but since our in New York State, especially the 5 boroughs in Long Island, the county clerk's office, if it's a nightmare everywhere else, it's a quadruple nightmare here.
Yeah, but realize they're dealing with people who have all made general deposits.
Okay.
And you're special.
Okay.
Okay? Once they realize that, you're not going to have to deal with the nightmare. But it might be a challenge getting them to recognize that. But you're not the average person that comes in there. Know that right now.
Right. So the first UCC should reflect that the promissory note was the special deposit.
Yeah.
Okay. Just want to make sure I haven't forgotten, what I learned.
So was this a FDIC one? You can get a lifting of the lien from them?
No, because it was Lend America, which is a mortgage company, not a bank. They said if they had, if they were a bank or for checking or savings account, we could have done it through FDIC. And right there on their website, they give you the fax, the email, the phone number, and they do provide release of liens, which was very surprising to me. I don't know what the conditions are, but I'm sure with a default judgment, we could have gotten it lifted if it was a bank.
You might want to do a show cause hearing as to why the county should not lift the lien based on the judgment.
Yeah, but they're going to basically say that there's nowhere in the decision where he's providing us a monetary award or releasing the lien. Basically, what it says, is that he...
How long has it been, Mara, since the ending of the case there, the last decision?
July 27th.
July 27th. This is August. So you still got time. Why don't you put in a motion to reconsider the relief? Resubmit.
I considered that, but I guess this judge, since he's such a hardball, it's making me a little nervous.
Well, you heard if you listened to the call earlier tonight, make him your trustee, and if he fails, you have about 10 different courses of action you can take against him.
Well, I find it hard to believe that he would reverse what he's already done.
Start a war with a former appellate court judge, and especially my friend. She's not strong enough to take on a war. I would, but she couldn't do it. And basically, he says the last sentence: plaintiff has failed to establish it was the owner of the note and mortgage at the commencement of the action. The complaint must and hereby is dismissed without prejudice. So he didn't give us a release. You have to do something in New York called a judgment roll. We are going to try to go in and move the lien with just this. But I doubt very seriously the county clerk will agree to that. But we're going to try first.
Well, you know what? Maybe he's looking for an order from you.
Okay, but as far as they're concerned, this case is closed.
Yeah.
But maybe you should
I don't even think index number is valid anymore.
30 days it would be, for 30 days.
Oh, it would?
Yeah.
Oh, okay.
That's why I say for 30 days you got an option. You can come back in and go in with a motion to reconsider, say, the judgment relief.
Oh.
Don't throw into question the judgment. Throw into question the relief, that it wasn't adequate enough. But I think you pretty much said it there in the last sentence, what he said. It wasn't proven that the plaintiff was the real holder and owner of the note, therefore it might be somebody else.
And if the plaintiff wasn't the holder, then who has the right to enforce a lien?
So, as you said earlier, above this, a defendant's pro se answer contains a standing defense. In support of its right to maintain the action, plaintiff relies upon an assignment of the mortgage dated September 1st, 2009 by MERS as nominee. Plaintiff has provided no evidence as to a transfer of ownership of the mortgage note. Assuming argumento that MERS as nominee had the authority to assign the mortgage, absent a transfer of the note which is secured, such assignment is a nullity, and he quotes the case.
Yeah, I think your better route is to come at the original lender, even though he's defunct. That would be working in your benefit, because the original lender had to be the owner and holder of the note at least at one time.
Right,
So
and that person who has the lien at the county.
Yeah, so then that one would get removed, didn't defend.
But do you think within the 30 days that I should ask him to modify the judgment? Or
Yeah, but you didn't. You'd have to come back in and incorporate these people on your pleadings in that. That wasn't done, was it? Were they joined in?
No. Well, I was just saying, okay, if I use that index number, I would have to use the plaintiff.
Yeah, we had his plaintiff on there who came at you. If it wasn't the original lender's name, then if you didn't join him in, then I can't see how you could really get this open back up and use that.
Okay, that's a good point.
So then the quiet title action against the original party would be the best thing, wouldn't it?
Yeah.
Right.
Because they're not going to show up anyway, because nobody's going to be there for them to show up.
Right.
And then you'll have your order.
Yes, and hopefully we should have.
And then the clerk's office won't be such a trouble. They'll say, "Oh, order, judge, we're good to go." Give them what they're used to seeing.
Right. Exactly.
Chris Skype me something, and I'm not sure what he means, so maybe you can help clear this up a little bit. I told him to get Lisa to unmute him, but anyways, he said encourage her to file for a judicial order for your administrative process, and then he also wrote AN, I don't know if Rule 55B1. Are you familiar with 55B1, Christian?
55, that's default, I think. B1, the clerk, I think, consign.
That's an idea. Maybe she could go ahead and file an action against them, a quiet title action, and then give them 20 days to respond, and then the clerk can certify it, couldn't they?
Yeah, because the clerk has the ability to certify a default when the party doesn't show up for, and then they can default them after the 20 days.
Chris can hear us. I guess Lisa won't.
Judge, the clerk can do that.
Myra, contact Chris Summers on Skype because it sounds like he's got a few ideas for you, but he can't come on for whatever reason and speak to you.
Oh, I just got muted.
Oh, okay. Hey, Chris.
Yeah. Congratulations on your wins. What has happened out here in California in U.S. District Court is when you complete a administrative process, no matter what it is, it could be a debt validation, it could be a clarification, it could be anything that you have completed as an administrative process against a financial institution, credit card, bank, mortgage, whatever. If you were to walk that into the clerk's office and have her issue you a certificate of default judgment, they're not looking at the contents. What they're looking at is the process. When you get a certificate of default judgment, not based off the contents, then you can actually obtain a writ of execution to execute it. Therefore, you've got several avenues that you can go about thereafter, because administrative processes, especially if you did it through a notary, and especially if you got a notarial protest, that in itself is a public witness, and what you need is a second public witness, which would be the certificate of default judgment, of which would seal the last nail in the coffin to go after these guys for everything, including damages, injuries, compensation, the several other different ways you can go after them. And it would also back the judgment the court gave you to be able to go after them, and even at the extent of what we're talking about and reviewing right now, which is an involuntary bankruptcy, where you have the U.S. Marshals come in and cease all their assets until this thing's straightened out, until you get paid.
Oh, okay.
Yeah, this is big. So we're not going to talk too much about that tonight, but I just wanted to mention to you that Rule 55 is big. And you can either go in and have the clerk look at your paperwork, and she'll see that you've already won the case, and all your administrative processes, she'll be basically giving you a certificate of default judgment on your administrative processes that she can see that followed the Administrative Procedures Act, that you gave these guys a chance. Now, if you have a half a dozen of them, the more the merrier, because she can check off and give a certificate for each one of those, and each one of those has value. Okay, so if she says, well, I can't do this for you, you're going to have to see a judge, probably what to do is kind of like a summary judgment hearing of where it could even be ex parte, because the other parties don't have to be there for an administrative hearing of your process. They've already got the papers, and basically all you're asking for is the certificate itself. So the chances are of having to call the other parties in is probably, I don't think, even necessary. But once you get those certificates, it's a done deal for them.
Okay, thank you.
Mm-hmm. You can really mess their program up with a certificate of default judgment, big time. Okay. That would benefit all the rest of us victims out here by their actions up to this point. Because if you seize all their assets and they cannot conduct, or if you take your instruments and you put that out as a lien against their corporations on Dun & Bradstreet, they cease to have any credit lended to them, and their commerce stops until they come back to the table and address your issues. They can't move. You can lock them up in several different ways, but U.S. Marshal, you can go to Dun & Bradstreet. Once you get on the credit, the public side of the credit report, and file that lien against them, it's a done deal until they come back to the table. They can't move edgewise. You could stop their whole business with one file with the Dun & Bradstreet.
Thank you.
Mm-hmm. Go get them, girl.
Yeah, I'm trying.
Well, you sound like you've done a good job. I mean, you sound very confident.
Thank you.
Yeah.
Well, we hit them with so much that they, we knew that right before the judgment, we had a feeling we were going to win because we received the nastiest letter from the attorneys. They called us moronic and, we're getting stuff off the internet. It was just beyond. They resorted to like 2-year-old tactics. I could not believe that an attorney would reduce themselves to that level. It was just incredible.
Hey, 10,000 attorneys at the bottom of the Marianas Trench is, right?
Right.
Good start. Right.
Exactly. So that's a sign when you're teeing off the attorneys and they can't have an intelligent legal conversation, chances are you won.
Yeah. Well, the beauty about some of the new considerations that we're thinking about, and I know that Christian had touched upon them earlier, the technology that we're starting to create is really going to put them in a tailspin. When they have no jurisdiction to step into a room of where your presentation is in equity and it's on the private side, and they're not to show up, no corporations or attorneys can show up to those meetings, it's pretty much a done deal.
Okay.
If you think about what small claims does, which is an equity court, no attorneys can show up in a small claims court. And in similarities, when you look at the equity side of the private side of an equity court, like in Chancery, when you invoke that type of a court, corporations and attorneys are not allowed in a courtroom. That means that only injured parties can show up, and since they have absolutely no proof of any injured parties that will show up, it's a done deal.
Okay.
So, anyway, I just wanted to mostly tell you about the Rule 55 because that's an important one a lot of people don't know about.
Okay, thank you. So that I'd have to take it to federal court, though, to invoke that.
Yeah, you may want to call the clerk and ask.
There's a state equivalent to that.
Oh, is there really? I didn't know that. Is that a summary judgment?
I don't know. You have to look in your rules to see what's the equivalent of Rule 55 in federal in your state. Okay, anything else, guys?
Yeah, Christian, I was just wondering if maybe sometime soon you'll do a night on extinguishment.
I suppose so, sooner or later.
Hey, Christian?
Yeah, is Myra done?
Yes, I'm done. Thank you.
Okay, well, the hard work that you did, you deserve it, so.
You were cutting out. I didn't hear what you said.
I was saying for all the hard work that she did, she deserved it.
Oh, absolutely. I think that all of us do. This is just another proof that we're going to get our country back, and that we just have to keep moving with what we're doing here. I wanted to let you know that I've got this book that has just been absolutely. I bought this at the law bookstore when Eric was out here. It's called The Duties and Liabilities of Corporation Officers and Directors. And as you were speaking, you and Eric were speaking, I was thumbing through the fiduciary duties and obligations and the breaches and the different liabilities and duties that they breach and whatnot. And almost everything you guys were talking about, I would just turn another page, and there's the information that they've got in this book, including all the penalties and prosecution angles that you can go about these officers. And it gives detailed information of how to go inside the SEC and inside the corporations to have the corporation go after their own officers for making their corporations liable.
Sounds like pay dirt.
And so that's part of what I posted over there at the teacher's site is just a few of the little nooks and crannies of the goodies that are in this book. But what I was thinking about doing is maybe passing this to the teachers so they can actually review it on some of the angles of how to go after these officers with the laws that they give us to go after them for. One of the big things that they were talking about in here is proxy rights. They were talking about stockholders and shareholders, and they were talking about principals. Well, if you just consider the person that signed their signature on a promissory note and that was converted unlawfully, it's still their assets, and because they were never asked for the consent for participating or sharing the profits, this is a major fraud and felonious charge that can come upon these people from what this book is saying. This is big.
Yeah, we might have to do some more research on the thing. We'll probably find out that everything we think we're coming at them with under fraud was really stemming from us. And we're the ones that abandoned it, and they're taking good care of it for us.
Here's a term that they use that we used to use in the debtor-creditor. The debtor-creditor was a closed union shop, which led everybody to the RICO and racketeering, of where there's a collusion between government and corporations to theft and pillage wealth out of the American people. But what they call it here in this book is insider profits. And they say that it's extremely unlawful. That means that Paul is paying Peter, which is to do the dirty work, and no one gets harmed from it, but there's someone directing it and someone else actually acting upon it, and because they're under corporate veil, no one's liable personally but the corporation, which has impunity. And they're saying that here that's not necessarily true, and they go into case law. They go into antitrust. They go into the several different acts that were passed to prevent this type of activity. And then they go back into the SEC in this book, and they talk about the same collusionary factors that these insider profit considerations between directors and corporate officers are plaguing the SEC, and they actually even give you the sites to go to file complaints.
Well, I would pick up on the antitrust that you mentioned first before I went with any of that other stuff.
Yeah. Well, I was just kind of like giving you a body of what this book is actually saying here, but it's pretty full of duties and obligations, and it's exactly what they have to follow. And this is part of their corporate charter. This is the Bible as far as what they've got to follow under corporate charter.
So we're corporate now, so it's
pardon?
all. I say the key word's all corporate, so it's on the debtor-creditor side. So,
well, the beauty about it is that's where they're at. Where we're at is we can attack them for what is in this Bible. They are subject to this Bible, not you and me, and we can attack. That's how important this thing is. Anyway, I just wanted to mention that because I thought this was a spectacular book for us to pick up on some of the different laws and stuff that they have to abide by. But anyway, great evening. Really appreciated everything. Everybody was just absolutely great. And I'll just let you guys go ahead and close down whenever you're ready.
Yeah, I'm ready to head out. So.
Right. Well, thank you for everything, Christian. You're such a blessing, and your mind is like a computer. It's just unbelievable how quick and spontaneous you are with coming up and answering people. I've only seen one or two people in my life that has that ability, and so I commend you for having that. I really do, because it's so precious to all of us to have that spontaneous response, and it's clear. And it's right on point. It's just amazing how you do that. So I just wanted to say thank you for having that capacity to be our master teacher in this group.
Well, thank the Lord for that one.
Yeah, I will. I will. Anyway, good night.
Thanks, Chris. Okay, thanks, Eric. Thanks, everybody on the call. Thanks for showing up, and we'll see you tomorrow night. Night, all.